witness bond. They went and got her, brought her back up on the sheriff's department. And she was
January 13th, 2025. Ms. Massengill, as well as Detective Price and myself, met with him, got information from him, contact information from him. He was to either contact us or be here on Monday in regards to the trial. He was not. I had our victim witness coordinator attempt to contact him yesterday. The phone number he had assured us he would be available at, and he has not responded to that. As a result, we would ask for him, KBS to be issued, and him to be brought before the court.
all right.
I've got a copy.
I do have to ask one question.
Yes.
And it's one of those, ask me how I know. He was actually served with a subpoena.
He was. I've attached a copy of the subpoena, Judge.
All right, I'm gonna order secure witness bond. He'll be brought before the court. I'll set a bond at that time. We need somebody to go out and find him right now.
I believe.
Here.
Detective Price is going to be able to assist us.
The reason I asked is to make sure that the person who served is years ago. Joe Felke and I went out, went to Food City down on Houston Road, interviewed this girl, told her when the date was, had the subpoena there. As soon as she saw it, she started crying, which got both Felke and me both rattled. She didn't show up, so Judge Beck ordered material witness bond. They went and got her, brought her back up on the sheriff's department. And she was obviously crying again and goes, but they didn't give me a subpoena. And we looked at the file and we hadn't actually.
There were three of us.
We had unarrested.
I understand. Judge, one other thing I want to take up, court order that the media not film anything we have open on computers or laptops. I'd ask the court to re-instruct the media that again today, because I think there's probably more here than that.
There's a big camera back there. Don't zoom in on whatever's on their laptops.
Right.
That goes for the folks sitting back here behind, for the state as well. Right. All right.
Judge, one other thing we could take up in regards to the indictment. The state is going to dismiss count 18.
Gotta make sure we got the right one. Count 18.
Yes, Your Honor.
All right. We'll have to redact that. Count 18 will be dismissed.
And Judge, we would ask the defense not to try to elicit any testimony in regards to that without putting on proof for evidence as well in regards to that count.
That's why it's dismissed.
Yeah. Well, any statements that might be made in that regard would, of course, be our position would be hearsay without the Ms. Boswell testifying. So.
Mr. Scott, before you do elicit any statements that relates to count 18, let's have a jury out, or at least a bench conference before we. Now, with regard to count 19, there's a note on here from the clerk's office. Is that code section correct? They say, should it be 312 instead of 314?
Judge, it should be 312, and we would move to amend that.
Any objection or discussion?
No.
I guess I'm gonna keep that, I'm gonna give this to you. At some point, they'll have to read it.
I bet this will be a fast trial. It probably won't last too many days. But we can always be surprised.
Anything else you want to take up before the jury?
Nothing else from the state.
Then we'll be in,
Go, sir.
then we'll be in recess. No, I got it. I can't stress enough how that if somebody tells me that a juror gets photographed or live streamed, how bad that day is going to go for everybody in this room. Okay. Also, during breaks, I want you to turn the sound off. All right. I think the jury is all here. They've ordered their. Can y'all hear me through the microphone? The jury has ordered their lunch. Or a chair down here on the flat. No, it can stay up there. Can everybody hear me? Can y'all hear me okay? All right. Before we begin the trial, I would like to tell you a little bit about what will happen during the course of the proceedings. I want to describe basically how the trial will be conducted and what the attorneys, jurors, and judge will be doing over the course of the trial. At the end of the trial, I will give you more detailed instructions on how you are to go about reaching a decision, but now I simply want to explain how the trial will proceed. The defendant has been charged by the state of Tennessee with a violation of state law. The document containing the charge is referred to as a presentment. A presentment is the formal accusation charging a defendant with a crime, and it's not evidence of anything. The defendant has pled not guilty to the charges. She is presumed innocent and may not be found guilty by you unless, after hearing all of the evidence, attorney's arguments, and instructions of law, the 12 jurors seated in this case unanimously find the state has proven its case beyond a reasonable doubt. The first step in the trial will be the attorney's opening statements. The state will tell you about the evidence it intends to present so that you will have an idea of what the state's case is about. This opening statement is not evidence. Its only purpose is to help you understand what the evidence will be and what the state will attempt to prove. After the state's opening statement, an attorney for the defendant may make an opening statement if he should so choose. Again, statements of attorneys are not evidence. Next will be the state's case in chief, in which the state will present its evidence. The evidence in the case will most likely consist of physical exhibits, documents, and the testimony of witnesses. The witnesses will testify by answering questions asked by the attorneys. After the state completes its case in chief, the defense will be given an opportunity to present evidence through witnesses and exhibits. A defendant is not required to put on any evidence or to testify. The burden is always on the state to convince you that the defendant is guilty beyond a reasonable doubt. If the defense does present proof, the state may then put on what is known as rebuttal proof. After you have heard all of the evidence, I will instruct you about the rules of law that you are to use in reaching your verdict. The final part of the trial occurs when the state and defense may present final arguments. I previously told you that opening statements by the attorneys are not evidence. Likewise, closing arguments are not evidence. In closing arguments, the parties will attempt to summarize their cases and help you understand the evidence that was presented. After you hear my instructions and the parties' closing arguments, I will select and excuse the alternate jurors, and the final 12 jurors will leave the courtroom together as a group. You will then begin your deliberations to make a decision in the case. Your deliberations will be secret, and you will not be required to explain your verdict to anyone. Now that I have described in outline form the trial itself, let me explain the functions that you and I will perform during the trial.
I will decide which rules of law apply to the case. My decision will be reflected in my responses to questions and objections the attorneys raised during the trial, as well as in my final jury instructions. It is your job to determine what the facts are from the evidence. You must then apply the law in my instructions to the facts, and from that application, you'll arrive at a verdict. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden remains on the state throughout the entire case. Keep in mind that the defendant is presumed to be innocent of the charges against her. Thus, the defendant is not required to prove her innocence, to have her attorneys make any statements or arguments, or to produce any evidence. Reasonable doubt is that doubt engendered by an investigation of all the proof in the case, and an inability after such investigation to let the mind rest easily as to the certainty of guilt. A conviction cannot be based on conjecture, suspicion, or mere belief that the defendant is guilty of the crime charged. Reasonable doubt is a high burden, but it does not mean proof with absolute certainty. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required, and this certainty is required as to every element of the offense. Reasonable doubt does not mean a captious, possible, or imaginary doubt. A reasonable doubt is not a whim, it is not speculation or suspicion, it is not an excuse to avoid the performance of an unpleasant duty, and it is not sympathy. A reasonable doubt is a doubt based on reason and common sense after careful and impartial consideration of all the evidence in this case. You, as jurors, must decide whether the state has proven beyond a reasonable doubt that the defendant has committed the crime charged in the presentment. You must consider the evidence in each count separately. You must base that decision only on the evidence in the case and my instructions about the law. An important part of your job will be making judgments about the testimony of the witnesses who testify. You should decide whether you believe what each person says and the importance of his or her testimony. In making that decision, I suggest you ask yourself a few questions. Did the person impress you as honest? Did he or she have any particular reason not to tell the truth? Did he or she have a personal interest in the outcome of the case? Did the witness seem to have a memory of the events he or she testified about? Did the witness have the opportunity and ability to observe accurately the things he or she testified about? Did he or she appear to understand the questions clearly and answer them directly? Did a witness's testimony differ from the testimony of other witnesses? These are a few of the considerations that will help you determine the accuracy of each witness's testimony. In making up your mind and reaching a verdict, do not base any decisions on the fact that there were more witnesses on one side than on the other. Likewise, do not reach a conclusion on a particular point just because more witnesses testified for one side on that point. Your job is to think about the testimony of each witness you heard and decide the facts. Some of you have probably heard the term circumstantial evidence and direct evidence. These are the two basic types of evidence that exist in law. Direct evidence is direct proof of the facts, such as the testimony of an eyewitness. Circumstantial evidence is proof of facts from which you may infer or conclude that other facts exist. I will give you further instructions on these as well as other matters at the end of the case. Keep in mind that you may consider both kinds of evidence which are considered to be of equal value in the law. The court will not provide you with a transcript of the testimony at the end of the trial. Therefore, you must listen very carefully to the testimony. Each of you will be allowed to take notes during the trial for your own use during your deliberations. You are not required to take notes. Independent memory can be as accurate as written notes. You will be provided with paper and pen if you decide to take notes. During the course of the trial, you should not talk with any witness, defendant, or attorney involved in this case. Please do not talk with them about any subject whatsoever. You may see them in the hallway or at some other location. If you do, perhaps the best standing rule is not to say anything. You also should not discuss this case among yourselves until I instruct you on the law and you start deliberating at the end of the case. It is important that you wait until all the evidence is received and you have heard all of my instructions on the rules of law before you deliberate among yourselves. During the course of the trial, you will receive all the evidence you may properly consider to decide the case. Because of this, you should not attempt to do any research on your own or gather any information on your own that you think might be helpful. Do not engage in any outside reading, visit any places mentioned in the case, or try to learn about the case outside of this courtroom in any other manner. I do not know, well, I do know. There will be media reports in the newspapers, on TV, or on the radio about this case. You are not permitted to read, watch, or listen to those reports. You, as jurors, must base your decision solely on the evidence you hear in the courtroom. At times during the trial, an attorney may make an objection to a question that is asked by another attorney or to an answer that a witness gives. This simply means the attorney is requesting that I make a decision on a particular rule of law. Do not draw any conclusions from the fact that an objection was made or from my ruling on that objection. My rulings only relate to the legal questions that I must determine and should not influence your thinking. If I sustain an objection to a question, the witness will not be permitted to answer the question. Do not attempt to guess what the answer might have been had the witness been permitted to give it. Similarly, if I tell you not to consider a particular statement that was made, you should put that statement out of your mind, and you may not refer to that statement in your later deliberations. You may not ask questions. It is the responsibility of the attorneys to present the evidence. You must decide the case on the evidence presented to you. However, during the course of the trial, I may ask a question or two of the witness. If I do, that does not indicate that I have any opinion about the facts in the case, or that I have any opinion with respect to that witness's credibility. Finally, during the course of the trial, I may have to interrupt the proceedings to confer with the attorneys about the rules of law which should apply. In some cases, we may have bench conferences in the courtroom outside of your hearing, and in some instances, I may ask you to retire to the jury room while we discuss the matter out of your presence. I ask your patience because these interruptions are necessary points in the trial where we have to resolve legal issues. If, after your deliberations, you find the defendant guilty of first-degree murder, we will then proceed to a sentencing, and you will set the punishment. If, after your deliberations, you find the defendant guilty of any other offense or offenses, the court will set the punishment at a separate sentencing hearing. The jury will not be involved in setting the punishment in those offenses. This completes my opening comments to you. We will now proceed with the reading of the presentment. General.
Thank you, Judge. Presentment, case number S-72-869, State of Tennessee, County of Sullivan. Criminal court charge, first-degree murder, count 1. The grand jurors for Sullivan County, Tennessee, being duly impaneled and sworn, upon their oath present and say that Megan Boswell, on or about December 2019, in the state and county aforesaid, and before the finding of this presentment, did unlawfully, feloniously, intentionally, and with premeditation kill Evelyn May Boswell, contrary to Tennessee Code annotated section 39-13-202A1, and against the peace and dignity of the state of Tennessee, signed Barry P. Staubus, District Attorney General. Charge, felony murder, count 2. The grand jurors for Sullivan County, Tennessee, being duly impaneled and sworn, upon their oath present and say that Megan Boswell, on or about December 2019, in the state and county aforesaid, and before the finding of this presentment, did unlawfully and feloniously kill Evelyn May Boswell, a human and being, said killing being committed in the perpetration of or attempt to perpetrate the felony crime of aggravated child abuse, contrary to Tennessee Code annotated section 39-13-202A2, and against the peace and dignity of the state of Tennessee, signed Barry P. Staubus, District Attorney General. Charge, felony murder, count 3. The grand jurors for Sullivan County, Tennessee, being duly impaneled and sworn, upon their oath present and say that Megan Boswell, on or about December 2019, in the state and county aforesaid, and before the finding of this presentment, did unlawfully and feloniously kill Evelyn May Boswell, a human and being, said killing being committed in the perpetration of or attempt to perpetrate the felony crime of aggravated child neglect, contrary to Tennessee Code annotated section 39-13-202A2, and against the peace and dignity of the state of Tennessee, signed Barry P. Staubus, District Attorney General. Charge, aggravated child abuse, count 4. The grand jurors for Sullivan County, Tennessee, being duly impaneled and sworn, upon their oath present and say that Megan Boswell, on or about December 2019, in the state and county aforesaid, and before the finding of this presentment, did unlawfully, feloniously, knowingly, and other than by accidental means, treat Evelyn May Boswell, date of birth November 21st, 2018, a child under 8 years of age, in such a manner as to inflict serious bodily injury, contrary to Tennessee Code annotated section 39-15-402, a Class A felony, and against the peace and dignity of the state of Tennessee, signed Barry P. Staubus, District Attorney General. Charge, aggravated child neglect, count 5. The grand jurors for Sullivan County, Tennessee, being duly impaneled and sworn, upon their oath present and say that Megan Boswell, on or about December 2019, in the state and county aforesaid and before the finding of this presentment did unlawfully, feloniously, and knowingly neglect a child, Evelyn May Boswell, date of birth November 21st, 2018, a child 8 years of age or less, so as to adversely affect the child's health and welfare. And the act of neglect resulted in serious bodily injury to the child, Evelyn May Boswell. Contrary to Tennessee Code Annotated Section 39-15-402, a Class A felony, and against the peace and dignity of the state of Tennessee, signed Barry P. Stavas, District Attorney General. Charge, tampering with evidence, count 6. The grand jurors for Sullivan County, Tennessee, being duly impaneled and sworn, upon their oath present and say that Megan Boswell, on or about December 2019, in the state and county aforesaid, and before the finding of this presentment, did unlawfully, knowingly, and feloniously alter, destroy, or conceal evidence with the intent to impair its availability, verity, or legibility as evidence in an investigation. The said Megan Boswell, knowing that an investigation was pending or in progress, contrary to Tennessee Code Annotated Section 39-16-503, a Class C felony, and against the peace and dignity of the state of Tennessee, signed Barry P. Stavas, District Attorney General. Charge, false report, count 7. The grand jurors for Sullivan County, Tennessee, being duly impaneled and sworn, upon their oath present and say that Megan Boswell, on or about February 18th, 2020, in the state and county aforesaid and before the finding of this presentment, did unlawfully, knowingly, and feloniously make a statement in response to a legitimate inquiry by Sullivan County Sheriff's Detective Tracy Harraz, a law enforcement officer, concerning a material fact about an offense or incident within the officer's concern, to wit, the disappearance of the defendant's infant daughter, Evelyn Boswell, knowing that the statement was false and with the intent to obstruct or hinder the officer from preventing the offense or incident from occurring or continuing to occur. The said false statement concerning Evelyn Boswell and the defendant's claim that her infant child was with the child's father, Ethan Perry, contrary to Tennessee Code Annotated Section 39-16-502, a Class D felony, and against the peace and dignity of the state of Tennessee, signed Barry P. Stavas, District Attorney General. Charge, false report, count 8. The grand jurors for Sullivan County, Tennessee, being duly impaneled and sworn, upon their oath present and say that Megan Boswell, on or about February 18th, 2020, in the state and county aforesaid and before the finding of this presentment, did unlawfully, knowingly, and feloniously make a statement in response to a legitimate inquiry by Sullivan County Sheriff's Detectives Michelle Gillum and Tracy Harraz, law enforcement officers, concerning a material fact about an offense or incident within the officer's concern, to wit, the disappearance of the defendant's infant daughter, Evelyn Boswell, knowing that the statement was false and with the intent to obstruct or hinder the officer from preventing the offense or incident from occurring or continuing to occur. The said false statement concerning the defendant's alleged lack of knowledge of the whereabouts of her infant daughter and her alleged efforts to locate her daughter, contrary to Tennessee Code Annotated Section 39-16-502, a Class D felony, and against the peace and dignity of the state of Tennessee, signed Barry P. Stavas, District Attorney General. Charge, false report, count 9. The grand jurors for Sullivan County, Tennessee, being duly impaneled and sworn, upon their oath present and say that Megan Boswell, on or about February 18th, 2020, in the state and county aforesaid and before the finding of this presentment, did unlawfully, knowingly, and feloniously make a statement in response to a legitimate inquiry by Sullivan County Sheriff's Detective Lieutenant Steve Williams, a law enforcement officer, concerning a material fact about an offense or incident the officer's concern, to wit, the disappearance of the defendant's infant daughter, Evelyn Boswell, knowing that the statement was false and with the intent to obstruct or hinder the officer from preventing the offense or incident from occurring or continuing to occur. The said false statement concerning the alleged last physical contact that the defendant had with her infant daughter, and Ethan Perry's alleged refusal to respond to her text and voicemails regarding her daughter following an argument with Ethan Perry about the custody arrangements concerning her daughter. Contrary to Tennessee Code Annotated, Section 39-16-502, a Class D felony, and against the peace and dignity of the state of Tennessee, signed Barry P. Staubus, District Attorney General. Charge, false report, count 10. The grand jurors for Sullivan County, Tennessee, being duly impaneled and sworn, upon their oath present and say that Megan Boswell, on or about February 18th, 2020, in the state and county aforesaid and before the finding of this presentment, did unlawfully, knowingly, and feloniously make a statement in response to a legitimate inquiry by Sullivan County Sheriff's Detective Captain Joey Strickler, a law enforcement officer, concerning a material fact about an offense or incident within the officer's concern, to wit, the disappearance of the defendant's infant daughter, Evelyn Boswell, knowing that the statement was false, and with the intent to obstruct or hinder the officer from preventing the offense or incident from occurring or continuing to occur. The said false statement concerning the defendant's alleged last physical contact with her infant daughter and the defendant's alleged lack of knowledge of the whereabouts of her infant daughter, even though she had concerns that her daughter was possibly injured. Contrary to Tennessee Code Annotated, Section 39-16-502, a Class D felony, and against the peace and dignity of the state of Tennessee, signed Barry P. Staubus, District Attorney General. Charge, false report, count 11. The grand jurors for Sullivan County, Tennessee, being duly impaneled and sworn, upon their oath, present and say that Megan Boswell, on or about February 19th, 2020, in the state and county aforesaid and before the finding of this presentment, did unlawfully, knowingly, and feloniously make a statement in response to a legitimate inquiry by Federal Bureau of Investigation agents Jeff Blanton and Todd Wilcox, law enforcement officers, concerning a material fact about an offense or incident within the officer's concern, to wit, the disappearance of the defendant's infant daughter, Evelyn Boswell, knowing that the statement was false and with the intent to obstruct or hinder the officer from preventing the offense or incident from occurring or continuing to occur. The said false statement concerning the alleged time frame of when the defendant gave her infant daughter to Ethan Perry to keep, since she could not handle her daughter anymore, and Ethan Perry's alleged threats to take the defendant to court to address the custody of their daughter. Contrary to Tennessee Code Annotated, Section 39-16-502, a Class D felony, and against the peace and dignity of the state of Tennessee, signed Barry P. Staubus, District Attorney General. Charge, false report, count 12. The grand jurors for Sullivan County, Tennessee, being duly impaneled and sworn, upon their oath, present and say that Megan Boswell, on or about February 20th, 2020, in the state and county aforesaid and before the finding of this presentment, did unlawfully, knowingly, and feloniously make a statement in response to a legitimate inquiry by Sullivan County Sheriff's Detective Captain Joey Strickler, a law enforcement officer, concerning a material fact about an offense or incident within the officer's concern, to wit, the disappearance of the defendant's infant daughter, Evelyn Boswell, knowing that the statement was false and with the intent to obstruct or hinder the officer from preventing the offense or incident from occurring or continuing to occur. The said false statement concerning the defendant's alleged claim that she last saw her infant daughter in the custody of Ethan Perry on December 26, 2019, and that she had not contacted the police to report her missing child on the advice of Angela Boswell, the defendant's mother. Contrary to Tennessee Code Annotated, Section 39-16-502, a Class D felony, and against the peace and dignity of the state of Tennessee, signed Barry P. Staubus, District Attorney General. Charge, false report, count 13. The grand jurors for Sullivan County, Tennessee, being duly impaneled and sworn, upon their oath, present and say that Megan Boswell, on or about February 20th, 2020, in the state and county aforesaid and before the finding of this presentment, did unlawfully, knowingly, and feloniously make a statement in response to a legitimate inquiry by Tennessee Bureau of Investigation agent David Gratz and Sullivan County Sheriff's Detective Sergeant Matt Price, law enforcement officers, concerning a material fact about an offense or incident within the officer's concern, to wit, the disappearance of the defendant's infant daughter, Evelyn Boswell, knowing that the statement was false and with the intent to obstruct or hinder the officer from preventing the offense or incident from occurring or continuing to occur. The said false statement concerning the defendant's mother, Angela Boswell, possibly having her infant daughter, but refusing to share with the defendant the location of her daughter and whether she had custody of the defendant's daughter. Contrary to Tennessee Code Annotated, Section 39-16-502, a Class D felony, and against the peace and dignity of the state of Tennessee, signed Barry P. Staubus, District Attorney General. Charge, false report, count 14. The grand jurors for Sullivan County, Tennessee, being duly impaneled and sworn, upon their oath present and say that Megan Boswell, on or about February 20th, 2020, in the state and county aforesaid, and before the finding of
Oops, sorry, I forgot I was muted. All right. So I just wanted to stop us real quick just to get a little break in and comment a little so we make sure we don't get struck or anything. But if you notice down there, it says it's the reading of the indictment. They're going to start out with opening statements, but don't they sometimes waive the reading of the indictment? This is a really long indictment. I don't remember. I always thought that they usually, the defense will usually waive the reading of the indictment. Do any of you all know if that's usually done in Tennessee?
this presentment, did unlawfully, knowingly, and feloniously make a statement in response to a legitimate inquiry by Tennessee Bureau of Investigation agent David Gratz and Sullivan County Sheriff's Detective Sergeant Matt Price, law enforcement officers, concerning a material fact about an offense or incident within the officer's concern, to wit, the disappearance of the defendant's infant daughter, Evelyn Boswell, knowing that the statement was false and with the intent to obstruct or hinder the officer from preventing the offense or incident from occurring or continuing to occur. The said false statement concerning the defendant's mother, Angela Boswell, allegedly having taken her infant daughter in mid-December of 2019 and refusing to tell the defendant of her daughter's location, and that she allegedly did not call the police to report her infant daughter missing out of fear that her mother, Angela Boswell, would harm Evelyn Boswell. Contrary to Tennessee Code Annotated, Section 39-16-502, a Class D felony, and against the peace and dignity of the state of Tennessee, signed Barry P. Staubus, District Attorney General. Charge, false report, count 15. The grand jurors for Sullivan County, Tennessee, being duly impaneled and sworn, upon their oath present and say that Megan Boswell, on or about February 20th, 2020, in the state and county aforesaid and before the finding of this presentment, did unlawfully, knowingly, and feloniously make a statement in response to a legitimate inquiry by Tennessee Bureau of Investigation agent David Gratz and Sullivan County Sheriff's Detective Sergeant Matt Price, law enforcement officers, concerning a material fact about an offense or incident within the officer's concern, to wit, the disappearance of the defendant's infant daughter, Evelyn Boswell, knowing that the statement was false and with the intent to obstruct or hinder the officer from preventing the offense or incident from occurring or continuing to occur. The said false statement concerning the defendant's mother, Angela Boswell, having allegedly taken her infant daughter because Angela Boswell believed that the defendant owed her money, and that the defendant's mother, Angela Boswell, had allegedly told her that Evelyn Boswell would not be returned to the defendant until the money was paid. Contrary to Tennessee Code Annotated, Section 39-16-502, a Class D felony, and against the peace and dignity of the state of Tennessee, signed Barry P. Staubus, District Attorney General. Charge, false report, count 16. The grand jurors for Sullivan County, Tennessee, being duly impaneled and sworn, upon their oath present and say that Megan Boswell, on or about February 21st, 2020, in the state and county aforesaid and before the finding of this presentment, did unlawfully, knowingly, and feloniously make a statement in response to a legitimate inquiry by Tennessee Bureau of Investigation Agent David Gratz and Sullivan County Sheriff's Detective Sergeant Matt Price, law enforcement officers, concerning a material fact about an offense or incident within the officer's concern, to wit, the disappearance of the defendant's infant daughter, Evelyn Boswell, knowing that the statement was false and with the intent to obstruct or hinder the officer from preventing the offense or incident from occurring or continuing to occur. The said false statement concerning her mother, Angela Boswell, allegedly having Evelyn Boswell at an unknown location, and that despite the efforts of the defendant to find her infant daughter, she allegedly did not know the whereabouts of her infant daughter and did not have any additional information to provide to law enforcement in their attempts to find the missing child. Contrary to Tennessee Code Annotated, Section 39-16-502, a Class D felony, and against the peace and dignity of the state of Tennessee, signed Barry P. Staubus, District Attorney General. Charge, false report, count 17. The grand jurors for Sullivan County, Tennessee, being duly impaneled and sworn, upon their oath present and say that Megan Boswell, on or about February 23rd, 2020, in the state and county aforesaid, and before the finding of this presentment, did unlawfully, knowingly, and feloniously make a statement in response to a legitimate inquiry by Tennessee Bureau of Investigation Assistant Agent in Charge, Chris Wilhoit, a law enforcement officer, concerning a material fact about an offense or incident within the officer's concern, to wit, the disappearance of the defendant's infant daughter, Evelyn Boswell. Knowing that the statement was false and with the intent to obstruct or hinder the officer from preventing the offense or incident from occurring or continuing to occur. Concerning the defendant's mother, Angela Boswell, allegedly having given the defendant's infant daughter, Evelyn Boswell, to another person who Angela Boswell refused to name, and that her infant child was safe and would have a better life with the unknown person than with the defendant. Contrary to Tennessee Code Annotated, Section 39-16-502, a Class D felony, and against the peace and dignity of the state of Tennessee, signed Barry P. Staubus, District Attorney General. Charge, abuse of a corpse, count 19. The grand jurors for Sullivan County, Tennessee, being duly impaneled and sworn, upon their oath present and say that Megan Boswell, on or about December 2019, in the state and county aforesaid, and before the finding of this presentment, did unlawfully, knowingly, and feloniously, and without legal privilege, physically mistreat a corpse in a manner offensive to the sensibilities of an ordinary person, contrary to Tennessee Code Annotated, Section 39-17-312, a Class E felony, and against the peace and dignity of the state of Tennessee, signed Barry P. Staubus, District Attorney General. Charge, failure to report a death under suspicious, unusual, or unnatural circumstances, count 20. The grand jurors for Sullivan County, Tennessee, being duly impaneled and sworn, upon their oath present and say that Megan Boswell, on or about December 2019, in the state and county aforesaid, and before the finding of this presentment, did unlawfully, knowingly, and feloniously fail to report the death of her infant daughter, Evelyn Boswell. to the county medical examiner, local police, district attorney general, or sheriff, where the death was from violence, trauma, or in any suspicious, unusual, or unnatural manner, contrary to Tennessee Code Annotated Section 38-7-108, a Class E felony, and against the peace and dignity of the state of Tennessee. Signed, Barry P. Staubus, District Attorney General. True bill was returned 22nd day of May 2024, and it's signed Sally Sierra, foreman of the grand jury.
Mr. Scott, how does Ms. Boswell plead each count?
Defendant pleads not guilty in every count.
Thank you, sir.
Right.
General, you have opening statements?
Yes, Your Honor.
Go ahead.
Good morning. Today we're going to talk about Evelyn Boswell for a few minutes. In 2019, Evelyn Boswell was a bright, growing little girl, full of life, healthy, learning to walk, learning to talk, doing all the things that a 12-month-old child would do. Which means today, 5 years later, Evelyn Boswell would be 6 years old. She would be possibly in kindergarten, learning to read, maybe taking her first ballet class or her first soccer game, learning to tie her shoes, all of the things that we think of that are firsts for 6-year-old children. But based upon the last 2 days of our jury selection, we all know that Evelyn Boswell is not going to do any of those things. We all know that all of that was taken away from her in December of 2019 by the defendant, Megan Boswell. And her life wasn't just cut short. It's not just a tragedy. Her life was violently ripped away from her. And we can all agree that it's a shock. It's a tragedy when a child dies. It's upsetting. It upsets all of us. You'll hear phrases like "gone too soon," "what a tragedy." A child has such a life ahead of them. And a lot of times it is a tragedy. And in this case, it's a tragedy too. But in this case, it was a preventable tragedy. There's so much more to this story that you are going to hear. Because Evelyn did not have to die. Evelyn could be here today. And so today, 5 years later, we are asking you to give justice to Evelyn Boswell. During this trial, you will learn that the one person, Evelyn's mother, Megan Boswell, who was entrusted more than anyone else to take care of her, to keep her safe, to protect her, that she failed her in the worst possible way. You will hear proof that the last time Evelyn Boswell was seen alive was December 6th, 2019. You're going to hear that date a few times during this trial. That is the last time that Evelyn Boswell was seen alive. And that was just a few weeks after her first birthday. And you're going to hear from many witnesses who saw Evelyn frequently, saw her all the time, family members, Megan Boswell's friends, that all of a sudden are like, where's Evelyn? Where's Evelyn? We're not seeing. They're concerned. And they would ask Megan Boswell about it. And every time Megan had an answer. Megan concocted a story. And I'm not going to tell you now what she said. You're going to hear that in the proof. But she told all kinds of different stories, depending on the person that she was talking to. And you will hear from those witnesses today. But you will hear, or this week, but you will hear there was concern. But, they knew Megan. They thought they knew Megan, I should say. And so they wanted to trust that what she was telling them was the truth. But it was not the truth. So after December, what happens next? We have Christmas, New Year's. Where's Evelyn? There is no Evelyn. You will not see any proof that Evelyn was seen at Christmas, New Year's. Then we jump to January. The entire month of January 2020, 31 days. Where's Evelyn? There's no Evelyn. People are really starting to get concerned, and Megan Boswell continues to concoct stories of where Evelyn is to try to help people make sense so she can keep this going. The entire month of February 2020. Where's Evelyn? Again, at this point, family is really starting to get concerned that they have not seen Evelyn. And they're asking questions. Months pass. We're not talking about weeks. We are talking about over 2.5 months that Evelyn Boswell is missing. The defendant is not even just canceling her well visits. She's no-showing. She's just not showing up because she knows where Evelyn is. But again, even to the pediatrician's office, she has to concoct a story about forgetting the appointment maybe, or I got my days mixed up. Always a story. Always a story. So we know now, we did not know then, but we know now that from early December, Evelyn Boswell, even though it had not been reported by Megan Boswell, Evelyn Boswell was a missing child from early December until almost the end of February. She was a missing child. And the only person who knew that, the person who was entrusted to take care of her the most, is the only person who knew that Evelyn was actually missing. And she just left it unreported. Over 2 months later, finally, Megan Boswell's dad, Tommy Boswell, finally essentially puts an ultimatum down on his daughter and says, I'm tired of the stories. If you don't show me my grandchild by the next day, I'm essentially calling the police. Well, Megan knew she could not do that, and she did not do that. And Tommy Boswell finally was the one to report Evelyn missing on February 18th of 2020. Finally, law enforcement gets involved. The Tennessee Bureau of Investigation gets involved. The FBI gets involved. All hands on deck to find this missing child. She's finally reported missing. But it's important to note that it was not Megan Boswell that reported her child missing. Megan Boswell never reported her child missing. So you're going to hear from December of 2019 until February of 2020, when it's finally reported, that the defendant's biggest believable story, that really is probably what kept the family from reporting earlier, is she was saying that Evelyn was with her father, Ethan Perry. And you'll hear a lot about Ethan Perry, and you'll get to hear from Ethan Perry yourselves. Ethan Perry is actually not Evelyn's father, but Megan led him to believe that he was the father. And everyone, for all purposes, also believed Ethan Perry was the father. So to the family, they're like, well, that's good. He's stepping up. The father's stepping up. That's good. We're proud of him. And that is the story that Megan Boswell told mostly to her family, to her friends. You were going to hear a lot of testimony about her just telling everyone that Ethan Perry has gotten Evelyn. First, you'll hear that they're trading weeks, but doesn't make sense because people are still not seeing Evelyn. So then Megan took it one step further, where he took her to court and got emergency custody, blaming her for something. And again, not true. There was never court. There were no documents. Juvenile court was never involved. It was just another story that Megan Boswell was telling because she knew where Evelyn was, and she had to keep perpetuating this lie. Interestingly enough, she didn't think it through completely because Ethan Perry at the time was in the Army in Louisiana. He lived in barracks, and I think we all understand and know that in the barracks, there's not going to be a toddler running around. But Megan Boswell, in perpetuating that story, she didn't care. She got the entire Army involved in this to go investigate this poor guy who was trying to serve our country in Louisiana. Pulling him out of his duty, I can't imagine the chaos that caused, all because Megan Boswell wanted to perpetuate this lie. And Ethan Perry didn't even see Evelyn in December. You will hear that he came in to visit his grandparents on leave. He never saw Evelyn Boswell over Christmas or over December. We all know why now. But at the time, Megan again tells the story. Evelyn has the flu. She can't come. And you will hear the testimony that.
Sorry, I had to unmute myself. Wouldn't you all have demanded to see, like, I think the dad should have demanded to see his daughter at Christmas, or I would have been calling somebody.
No one saw. No one, not Ethan Perry or anyone else saw Evelyn Boswell in December. The hard part. From early December of 2019 until later when her body was found, Evelyn was always in the same place. And Megan Boswell knew that. Megan Boswell knew that because she is the one that put Evelyn there. She placed Evelyn's body in a kitchen trash can, her own trash can from her home, from the trailer that she shared with Evelyn. And she hid that trash can in her own childhood playhouse on her father's property, a playhouse that you will see no one has been in for a very long time. And that it was Megan's. It was personal to Megan, not to anyone else. And you're going to hear that Evelyn was put into the trash can upside down is the best way to describe it, head down, in a bag of trash filled with food debris, broken eggs, her body just placed in there by the defendant. You will see that there was a blanket tightly wrapped around Evelyn's body, pulled up over her face, and quite a bit of aluminum foil then wrapped around her head. The blanket completely covering her face, the foil completely covering her head. Upside down in a trash can, still in her purple fleece onesie and diaper. And as terrible as it is to say, you are going to hear that she just wasn't placed in the trash can, but then another trash bag was placed on top of her. And that trash bag was shoved down into the trash can, compressing Evelyn into the trash can. That's what we're dealing with today. And you're going to hear proof that directly links only one person to this crime, this horrendous crime. You are going to hear that the only person linked to this crime is sitting at this table right here. You are going to hear it from many witnesses. You're going to hear all of the stories that she concocted, the lies that she told, and you're going to hear forensic evidence that links the defendant, Megan Boswell, and only the defendant, Megan Boswell, to this crime. One step further. this entire time, Evelyn is decaying, decomposing in this trash can, again, upside down and compressed. What is Megan Boswell doing? Is she mourning her child? Is she worried? Is she scared? What is she doing? What would a mother be doing? Well, it's not what Megan Boswell was doing. And you're going to hear that because Megan Boswell got a new boyfriend, and it conveniently happened at pretty much exactly the same time that Evelyn disappears. When no one sees Evelyn again, Megan Boswell has decided she's just going to, Evelyn just out of the head, and she's moving on with her life. And she is living her best life, and you will hear that. She has this new boyfriend who has money, or at least she thinks he has money, and she's going to have a better life for herself. Not her child, but for herself. You will hear that she takes trips. She's clearly falling in love. She moves out of the trailer that she was living in with her child and moves in with this guy within weeks into his home in a very nice neighborhood in Bluntville, Tennessee. You are going to hear testimony that Megan Boswell is taking trips to Gatlinburg, to Pigeon Forge, staying at Margaritaville Hotel, all while her child is upside down, decomposing in a trash can. You will never hear that Megan Boswell was upset, mourning her child, crying. All she does is continue to concoct lies to cover up what she did. Is that what a mother does? So you will hear that when Tommy Boswell reports, it's essentially all hands on deck with law enforcement. Immediately, law enforcement goes into action, and you are going to hear so much proof about how much effort went into finding this baby, how much time and hours worked by every law enforcement agency in North Carolina, East Tennessee, Middle Tennessee. Everyone putting their efforts into trying to find this little girl and just hoping to find her alive. So then Megan Boswell then, of course, comes clean, right? Once law enforcement's involved, because Megan knows where Evelyn is, so she's gonna tell law enforcement, right? The answer is no, and you probably can gather that by General Harper reading the indictment for about 40 minutes this morning. Megan Boswell continues to perpetuate her stories, concocting anything, blaming anyone else, Ethan Perry, for a day, 2 days. She continues that story of Ethan Perry. Then you'll hear she admits that's not true. So then she tries to blame her mom, her own mom. She decides to try to blame to try to get out of this because she knows this snowball is rolling down this hill and she's trying to stop it the best she can. Why is she doing that? It's because she knows that she brutally murdered her child and she's trying to cover it up. And maybe she had that hope that Evelyn would never be found. And even to this day, 5 years later, Evelyn would still be a missing child. The defense said something really interesting in jury selection yesterday afternoon that I want to touch on. He said to you, you only have one chance to get this right. Do you remember that? Then he said, Megan only has one chance to get this right. Do you remember that? I submit to you, Megan Boswell has already had her chance. She was gifted with a beautiful child, a healthy, vibrant little girl. Evelyn was perfect. Megan Boswell already had her chance. So today is Evelyn's chance. Today is our chance to get it right, not Megan's. Today's our chance to get it right for Evelyn. I know this is not easy for any of you. Thank you for serving. I promise you that this is not easy for any of us. It is not easy for any of us. But it's so important for us to be here today. You know you're going to see pictures that you don't want to see. You know you're going to hear things that you don't want to hear. But that's how we tell Evelyn's story. What she endured before her death, during her death, and even after her death. And where she had to sit for months while her mother continued to live her life as if Evelyn didn't exist. Ladies and gentlemen, at the close of this proof, we believe you will be left with no doubt at all, that the defendant, Megan Boswell, is guilty as charged in every count of the indictment. Thank you.
Thank you, Joe. Mr. Scott.
Morning. She's right about some things. And this is a terrible situation. There's a child, 13-month-old child, dead in a crash pit. No getting around that.
Hold on just a minute. Ladies and gentlemen, I'm going to have you go to the officer.
Stand, please, so what happened? Maybe see the things.
Who are you with? All right. Are you the designated still photographer?
Yes, sir.
If that flash goes off again, you'll have 10 days in jail.
Sorry.
The order's very clear.
Yes, Your
There'll be no lights, there'll be no flash. That's disruptive to the jury. That's disruptive to the lawyers. That's disruptive to this process. And I'm not even kidding. If I see another light, whoever it comes from will immediately be held in criminal contempt of this court, taken to a jail for 10 days.
Yes, Your Honor, I'm sorry. I have it on not flash on my settings.
Well,
I
it
need-
went off because it was right in my face. Now, I got a feeling that one or two of them is going to take it back. It's going to mean it's going to take us like 15 minutes to get started. So we'll take about 10 minutes.
Thank you. Court stands in recess.
Okay, so they're on a short break. What do you guys think? Man, oh man. The media people, they sure get in trouble. Let's see. Yeah, they'll be back. Bugman. Everybody's just going to the bathroom and stuff, I guess. Jessica says, I want the media there, but I also want them to behave. Oh. Oh, wow. He's not pulling any punches. 10 days, though. That's a bit excessive and abuse of power. Well, they have all the power. Judge can. That young thug trial in Georgia was the craziest thing I've ever seen in a courtroom. It was constant drama. And the first judge was the main cause of most of it. Let's see. If she'd been out there among those searching herself, there wouldn't have been any threats or not understanding. But this case right here is too much. Defense is being whiny. They are working to get media removed. Yeah, they'll be back. Yeah, that's what I said at the beginning. I don't think this trial will last very long. I also saw where a young girl, she looked to be in her early 20s. She was charged with her baby dying from a blow dryer, y'all, like a hair blow dryer. She put the blow dryer in the bassinet with the baby and turned it on, and it burnt the baby bad, and she died. It's absolutely horrendous. The girl was on rugs, and she she admitted to sticking the hairdryer in the baby's bed, said she was trying to warm it. And she was on rugs, and she nodded off. She absolutely nodded off in a hairdryer. I mean, I couldn't imagine. Most of us women have blown dried our hair. How many of you have burnt yourself with that blow dryer? I couldn't imagine. Little baby skin's awful tender. I just cannot imagine what goes through these women's minds. We have no idea what she has and has not done in his case. I do know by some legal issues going to the state reps, you'd be surprised her help to the children of the future for cases like it. I think I'm out of the loop. I have a knee replacement Friday. I'm going to be down for a while. It would be so nice to have you all to hang out with on a trial. Yay! Absolutely. Yeah. Vicky says, I haven't heard anything about Megan being on rugs, though. Have y'all? I don't know. They said that they were, that her mom and her boyfriend were. I heard that Megan was kind of a casualty of her mom's crazy life. And her dad seems to have had some money. So I'd say she was just a spoiled brat. That's what I'm guessing. She's a spoiled brat that got her way. And I think somebody said it earlier, and she's never had to face any consequences for her actions. I think that ends up being for a lot of young people. Mommy and daddy bail you out all the time, and you've never had to suffer any consequences. I watch body cams all the time, and I'm just so surprised how many first time people they start crying and going on. I can't go to jail. I can't go to jail. I can't go to jail. Well, you're going. So you might as well get over that. You're going. Craziness. Vicky says, I think her dad has a paving company. I haven't seen her. Well, yeah, her dad's the one that called the police, wasn't it? Wasn't it her dad that called, finally did call? Kathy says, my kids' new actions had consequences. Good actions had good ones. Bad had bad ones. They're raising their kids the same way. Thank goodness. That's awesome, Miss Kathy. That's exactly right. You know, it's like a dog. I mean, I'm not comparing kid to a dog, of course, but how do you train a dog? Well, you reward good behavior. It's the same way with a child. You reward good behavior. Bad behavior is met with consequences. Parenthood sure doesn't come with a owner's manual or an instruction booklet. That is for sure. And usually the oldest child is very different from the baby. The first child gets all brand new everything, gets all the fuss. And then the more you have, the more they get the hand-me-downs, you know. Name brand might not be so important. By the fifth one you have, or however many. Vicky says, that would be me. I would not last a minute in jail. It's traumatizing. It really, really is. When a police officer puts handcuffs on you and your liberty, your freedom is taken, and they put you in that little cramped car back seat, take you to a nasty old cold, drafty concrete block. It's awful. It is absolutely awful. Onyx Angel says, yes, her dad called. Thank you. Yes, I just saw that this morning. Michael Jordan's grown son just pulled the dad card in a DUI charge. I saw that too. Onyx Angel says, preach, Kathy. Kathy says, I was the oldest, so I was the test child. My sister was the one that got away with everything. Yeah. No. Thank you. I have to remind myself I look terrible in orange. That's right. Orange and white stripes. Some of them are. Many people don't know the difference between discipline and punishment. Yeah. And there's a whole lot of them that don't know the difference between discipline, punishment, and abuse. You know, Bunny said, did Michael Jordan's son get away with it? And Lois said, nope. Yeah, Genevieve. Many people don't know the difference. I remind myself I like to shower alone and unwashed. That's right. Exactly. And there's no privacy in jail. You know, you go in those little cells and there's a little metal toilet and sink combo. So your drinking water comes right out from above the toilet. Like that's sanitary. But so and you've got one toilet in a little cell. Depending on how many people they have in the cell, depends on how many, or if the jail is overcrowded or not, which most of them are. So if they do have metal bunks attached to the wall, it's just a piece of metal slab that you put a little bitty tiny thin mattress over. It's not even a mattress. It's just a big dog bed, really. And so if there's more, if it's overcrowded, then they put their mats on the floor. So you've got 2 on the wall, and then you got however many in the floor. And if you got to go number 2, then you go number 2 with everybody else in there who can see you. So it doesn't matter if you got to go number 1 or number 2. It don't matter. You're still doing it in front of everybody in the cell. And if you're in just one great big room, I've seen that's why Letcher County, they've got one great big cell. Well, they've got more than one, but the one that I was in was just one great big cell. It's just one great big cement block room with one toilet and sink combo. And there was about 20 girls in there. And there was no beds. There was no metal on the wall. Okay, we're back, y'all. I'll shut up now.
All right. Whoever's muting the Zoom, stop. I'll be in charge of muting the Zoom.
One stand, please. You may be seated. Thank you.
Ladies and gentlemen, I apologize for the parade. I just want you to know that wasn't the fault of any of the lawyers or the parties. It was just a procedural issue I had to take care of. Okay? Now, Mr. Scott, I believe you were about to begin your opening statement.
Don't really know where I was at.
Just start over.
I was. That was the first line. I don't really know where I was at, but Miss Massey, she's right about a lot of things. I mean, there's not a person in this courtroom that wants to be here discussing a dead child. Nobody. Not you all, not me. But the state asks you to convict Megan Boswell of first-degree murder. It's very interesting what they've done. They've asked you to convict Megan Boswell of first-degree murder in 3 different ways. They've asked you to find that it's a premeditated and intentional killing of her child. And then they're asking you to find that it's a murder that is perpetrated as part of child abuse. And then they're saying, well, if it's not that, surely it's because of child neglect. That's a problem. The state's theory is reasonable doubt in and of itself. They don't know what happened. They don't know how that child died. And they can't prove how that child died. I expect you'll hear from a couple of different medical examiners who come to somewhat the same conclusion, but one medical examiner, I think you'll hear from her, and she's went to, she has a very interesting theory. But I would suggest to you that her theory is flawed. And the proof will show you why it's flawed. Just like yesterday I was talking about in voir dire, I think I asked a couple of you about the scientific method. And if you put in incorrect data, would you get incorrect results? And you will, if it's data significance. The state asks you, I anticipate this medical examiner, based on her testimony in another hearing, is going to say that this child was alive when it was placed in the trash can. But then again, the state says Megan's guilty of abuse of a corpse. Those theories are not consistent. They're not consistent with this. What the state hasn't talked to you about is the possibility of what if this was accidental? What if Megan or Hunter Wood rolled over on that child in the bed? And I find this unreasonable, honestly. I find it unreasonable that you roll over on your child in the bed and you don't call 911. And I'm 49 years old. I practiced law for close to 25 years. Mr. Harper talked about yesterday how your life experiences are different. But mine are certainly different than Megan's. When this child died, she was 18 years old. Now, you heard about what a great father Tommy Boswell was, and how involved he was. What you didn't hear is Megan had that child because while she was in foster care. That's how involved Tommy Boswell was. She was in foster care when she had the child. I think you'll hear a lot in this trial about how she came up. And I like to tell people, and I do tell people, I've never had a hard day in my life. I've never went hungry. I've never not had a place to live. I've never fought a war, and I've never lost a child. And I can't put myself in the position of someone who has lost a child. But that's what I'm going to ask you to do. Put yourself in Megan Boswell's position. She's 18 years old. She's got an older boyfriend. We expect the proof will be that he tells her, don't involve me with this. I don't want to be involved. Because they're scared they're going to get charged with something. That's going to be the proof in this case. And my reaction and your reaction would be different. I would certainly call 911. But I'm not 18 years old. And sometimes I think back to myself and I say, I want to call 911 at 18 years old. And I probably would. But I know a lot of people at 18 years old that wouldn't. Their life experiences are different. Their maturity is different. If any of you have kids, some of you probably know that. Now, I want to talk to you about about the indictment itself. We entered a not guilty plea to each and every count, and we persisted in that. But that probably seems disingenuous to some of you all about certain things, and I want to explain why. Counts 7 through 17 charge false report. And to find the false report, they have alleged that she has acted with the intent to obstruct or hinder an officer from preventing the offense or incident from occurring. Well, in the case of the death of her daughter, the death had already occurred, but she gave those statements. So it's not to hinder an officer in preventing the offense now, or from continuing to occur. That's the first thing. So you have to determine, is she criminally responsible? Did she lie to the police? She absolutely lied to the police. I'm not contesting that. Some of the stuff she said, again, are an 18-year-old girl scared to death, talking to a TBI agent, talking to a police officer, and trying to explain this. She doesn't want to get in trouble. It doesn't mean she murdered her child. It doesn't mean she killed her child. What it means is that's her perception that she's going to get in trouble for this. And despite all the assertions to the contrary by the state, this is a trial, and I want to choose my words carefully. Ms. Massengill talks about Evelyn. How to get this right for Evelyn. Get justice for Evelyn. Now, I want you to hear me out before you judge my statement. There's nothing you all are going to do that's going to change anything for Evelyn. Not a thing. The child, gone. Your job here today, and in the coming days and weeks, is to decide whether Megan's actions are criminal or whether they're not criminal. I'm not asking you to find her innocent of anything, because that's not your function. Your job is to determine whether the state can prove beyond a reasonable doubt and to a moral certainty that she committed each and every element of the offenses charged. And you're not going to be able to do that. Their theories are absolutely inconsistent. Premeditated murder, oh, well, if we get through that, maybe we'll get her by neglect. And I would suggest to you that the investigation into this case, once it focused on Megan Boswell, it focused on Megan Boswell. You'll see what little investigation there was into Hunter Wood, the boyfriend that they talk about. Who, it's like he's out of the picture. It's just Megan that did this. Well, we expect the proof will show you that he was involved with it, that he placed that baby there, that he had access to that property. That he'd been a lifelong friend of Megan's brother, Tommy Boswell Jr., who goes by Mikey. He knew where that stuff was. Now, there are other things about the body and how it was found that will come out in the proof. And I'll bring those to your attention later. But they will show you that baby wasn't placed in that trash container. They will indicate to you that baby was probably moved. Also, I want to touch again on Massengill's talking about Tommy Boswell. Tommy Boswell just had an epiphany. Well, he had an epiphany after they searched his property over and over, after they had run a cadaver dog by that building where the baby was that didn't get on it. Then one day he'll just pick up the phone and say, hey, I just got to thinking, Megan had this playhouse down here. Maybe you should come and search it. Cadaver dog didn't get it. Seems strange that the TBI searches your property and you would say, search all the buildings. Look at the playhouse. Why? Why do you have an epiphany days later? I bet I know where the child is. You'll hear from him. You'll hear him explain it. You can make your determination if you believe it. But ultimately, your task was determining whether Megan killed that child. The child could have died sudden death syndrome. It's an upper range of sudden death syndrome, but it's still there. And that child, I think that child's date of birth is middle of November. So when we say a 13-month-old child, the child was barely 13 months. Could have died from that. It could have died from someone rolling over, as they believe. Just negative. And certainly, disposing of that body the way it was disposed of is not excusable. It doesn't excuse anything. It doesn't make it right. It doesn't mean she's murdered. It doesn't mean that. I want to talk to you about the last count that we pled not guilty to on abuse or failure to report a suspicious death. And as indicted, the state chose to indict that where the death was from violence, trauma, or any suspicious or unusual, unnatural manner. Now, I can't deny she didn't report it. She didn't report it. There's no denying that. But what I would tell you is what that indictment leaves out is a key part of that statute. And had it included that, I would have pled guilty, had her plead guilty to that. And that talks about where the unexpected death of a child that's good health or sudden if death syndrome. Had that have been included, should have stood up and said, I'm guilty of that. I did that. It's not included because the indictment wants to make it that she committed a violent offense against the child. Lying to the police, improper disposal of the body, or whatever part she played in that, doesn't mean she murdered the child. It means she was an 18-year-old girl with pain. That's what you have to think about when you hear this proof. That's all I've got to say to you. I thank you for your time and attention. I know I'll probably cross-examine you. A lot of you fairly hard the other day. And I mean no disrespect by that. I just want you to know the jury selection process. I did that because we have to have jurors that, make sure that you can be a good juror. That's the only reason. I mean, absolutely no disrespect. If I'm hard on you, I apologize for that, but I don't apologize for standing up for me.
Thank you, Scott. General 21st.
State would call Agent Brian Frail.
right hand, raise forward, please. State your name.
Brian Frey.
You solemnly swear affirm testimony about to give you the truth, the whole truth, and nothing but the truth.
Yes, sir, I do.
Good morning.
Good morning, sir.
If you would introduce yourself to the jury, please.
Good morning. My name is Brian Fraley, and I'm a special agent with Tennessee Bureau of Investigation.
Agent Fraley, how long have you been with the Tennessee Bureau of Investigation?
19 years.
What is your current position or assignment there?
Senior special agent out of the Johnson City office, assigned to the Criminal Investigation Division.
Agent Fraley, were you called upon to assist in the investigation into the disappearance and subsequently the death of Evelyn Boswell?
Yes, sir, I was.
All right. And do you remember when that was that you were called out to assist in that?
Yes, sir. It was February 19th of 2020.
Okay. And what was your role when you first got called out?
Myself and other agents were called to assist Special Agent Brian Pritchard. He had been called to Sullivan County to assist Sullivan County Sheriff's Department on an Amber Alert on the 18th the previous day.
Okay. And so when you were first called out, this investigation was in regards to a missing child. Is that correct?
That's correct. Special Agent Pritchard had been contacted on a missing person case that involved Evelyn Boswell. Tennessee Bureau of Investigation is the only state agency that can actually issue Amber Alerts. We were informed that the initial complaint by a family member, being the grandfather of Evelyn, was Tommy Boswell through Department of Children's Services, also known as DCS, who had contacted the referral to the Sullivan County Sheriff's Department. Sullivan County Sheriff's Department got that referral, contacted us, and Special Agent Pritchard responded after going through a checklist that is required. Instead of just a regular missing person or missing child case, certain things have to be checked off or validated in order to issue a full-blown Amber Alert.
And Agent Fraley, I know you work for the TBI. Were there other law enforcement agencies that were involved in this investigation?
Yes, sir. Once it went to a full Amber Alert, which is probably our highest priority at TBI, the FBI was called. Obviously, Sullivan County Sheriff's Department investigators were already involved along with Agent Pritchard. But once we were involved, we have a specific team just for Amber Alert cases out of Nashville that also involve other agents and intelligence analysts. The FBI has a specialized team of trained agents called a CART team, and that's a child abduction response team. And these agents are experts in child abduction, Amber Alert type cases. So within hours of the Amber Alert being issued and certified, there was approximately 40 to 50 FBI, TBI, Sullivan County investigators, and intelligence analysts assigned to this case.
So a number of agents across a number of agencies, all out there, essentially, at least initially, looking for a missing child. Is that
Yes,
a fair
sir.
statement?
That's
Okay.
correct.
All right. And so over the first couple of days of your investigation, did you participate in or were you aware of interviews that were done with the defendant, Megan Boswell?
Yes, sir. Megan Boswell provided statements to a numerous amount of investigators early on, including me.
All right. And would it be a fair statement to say that she gave you multiple different versions about what had happened and where her child might be located?
Yes, sir. Repeated stories that we tracked down that turned out to be lies. Were
Objection, Your Honor. No, that's speculation.
As to the word lies,
May I continue?
Yes.
Just different statements that she had provided that turned out to be leads that we tracked down over the course of several days and several weeks.
And I guess let me ask you this way, Agent Fraley. Okay, I'm sorry. Were you all ever able to locate Evelyn Boswell?
Yes, sir, we were.
All right. And was that as a result of information? Well, I guess go ahead and tell me how it was that you were able to.
So on March 6th, which this is fast forwarding 17 days since I was brought in with other investigators, 18 days since the initial report on February 18th. We'd been working around the clock. And like I said, there was 40 to 50 of us working, and a phone call was received by Tommy Boswell. Tommy Boswell had called in. And March 6th, 2020 was a Friday. And we had worked, like I said, 18 days. And we had come to a point in the investigation where we decided we need a break. We had exhausted a lot of resources, time, and we were a place where we didn't feel we should go on at that time. We should take a break, and it was a good pause point, if you will. So on the afternoon of March 6th, again, as a Friday, the plan was the investigators to go home, reset physically and mentally. We were exhausted, and try to just get a sense of normalcy, if you will, over the weekend and come back Monday. If anything would have come up, we would have responded. But in late afternoon on the March 6th, on the Friday, Tommy Boswell called in. So we agreed, the four of us, myself, Special Agent Gratz, who's also another TBI agent, investigator Tracy Raz, who is a Sullivan County detective at the time, and investigator Michelle Gillum, who was an investigator at the time. We'd been working together for those weeks. We decided, let me back up. Mr. Boswell reported that he wasn't sure if there was a storage.
Objection is what Mr. Boswell says.
Well, Judge, I'm not offering further.
Sustained.
Agent Fraley, as a result of the call that you got, and let's step back a little bit. Tommy Boswell is the defendant's father. Is that correct?
Yes, Megan's father and Evelyn's grandfather.
All right. As a result of the phone call that you received from Mr. Boswell, what did you all do next?
We went to Mr. Boswell property located on Muddy Creek to conduct a search there.
All right. And is that property located in Sullivan County?
Yes, sir.
All right.
I think it's 539
All right.
Muddy Creek Road.
All right. Agent Fraley, in the course of your investigation while you were out there, did you create a sketch or diagram of the Boswell property?
Yes, sir, I did.
All right. If I could, I'm going to hand you a document, ask you if you can identify what's shown.
Excuse me. This is a hand-drawn document. It's a sketch of like an aerial view of the property there at Mr. Boswell's at 539 Muddy Creek Road, Bluntville, Tennessee.
All right. And does that diagram accurately show the layout or the placements of various sheds, outbuildings, trailers, roadways there on the property?
Yes, sir, it does.
All right. Judge, we would move to make that exhibit number 6.
Any objections?
No, sir.
Be fully consent.
And if we could, I'd like to publish that to the jury.
Or you can use the emerald thing.
Well, I'm Judge, Agent Fairley may need to step down. I don't know if he can. I may need him to step down for the witness. I don't know if he can. If I could hand him a laser pointer.
Okay. He needs to, that's fine. As long as we can pick him up on.
I can see that.
Can you
from-
see it okay
Yes,
from there?
sir.
I didn't know if you would be able to. All right. Are you okay from
Yes, sir. I can see that.
shooting?
And I have it in front of me as well
Okay.
on my screen.
All right. If you would kind of point out, I guess, the major landmarks that are shown there in the diagram.
Yes, sir. So this top house here is Tommy Boswell's, as it was described to us. This resident here was a mobile home that was described as his mother's. This is the shed that we had information on right there. That's like a yard barn or an outbuilding. And then here is notated as what we described and what was described as a playhouse.
I don't know what happened.
Hold on a second.
It's like it lost your speed.
Judge, it's not connecting.
You want to just stick it
I
in?
was going to say, if you'll just hand me the.
You gotta drag it up. That's stay up. Maybe what, just do that.
It did. Okay.
There's something. There you go.
You need me to disconnect the laptop, Judge? or-
This, I can
You can-
change it.
Okay.
Zoom in and out. There you go. Continue.
Yes, continue, please.
All right. So yes, right here, behind that shed or yard barn, if you will, was a playhouse, and it's noted Playhouse ROE. ROE is an acronym for us for Recovery of Evidence, which was the body of Evelyn Boswell. Up in the right-hand corner is my notes are like a key to this, which indicates the date, our case number, the location, and my signature with the date, notating that I was the one that drew this sketch.
Agent Fairley, you've got the driveway shown through the middle part of that diagram there. Was there any sort of gate or anything that, as far as being able to enter or exit the property?
I recall, I think there was a gate at the bottom from Muddy Creek Road to the driveway.
Okay. Now, Agent Fraley, you identified an outbuilding that was there on the property. You had said that's where you went first.
That's correct.
Okay. And I guess tell us what you found or what you observed when you went to that outbuilding.
What was found there were multiple boxes of belongings of Megan Boswell that contained a variety of items specific to a young child. I recall there were clothing items, diapers, medicines, toys, those kind of things were the most common thing in those boxes.
Agent Fraley, I'm going to show you 3 photographs and ask you if you can identify what's shown in those.
And so the first one is the yard barn or shed that was described and depicted in the sketch. The home there to the right was, our understanding, Tommy's mother. The second, that's the first one. The second one is the same yard barn or shed, except in this one it has a picture of the what we were describing as a playhouse behind it. And then the third and final one is a closer photograph of the yard barn or shed with those items I just described.
And those photos accurately show how that shed or outbuilding looked when you arrived there on March the 6th, 2020.
Yes, sir, it does.
Judge, we would move to make those the next exhibits, which I think are 7, 8, and 9.
Any objection?
No, sir.
Before we exhibit. How do you want to display those?
Well, I'll take another
Shot
at trying to use the laptop.
General, which order did you want these pictures marked?
Whatever.
I want them the way you described them. First one, the yard barn with the home. Second one's the yard barn with the playhouse behind it. Third one's the close second to the yard barn behind it.
May I see those? Make sure you've got the. All right, Agent Fraley, I'm got up on the screen what's been introduced as Exhibit 7. If you would tell the jury what they're looking at.
So this is the yard barn or shed that I was describing. This was the home that was described to us as Tommy Boswell's mother. And then the items there that you can see with the open door inside of the shed or yard barn.
And next is Exhibit 8.
Yes, sir. Again, the yard barn with the door open, showing those items described. And this building here behind the yard barn is what I described and is notated on my sketch as the playhouse where Evelyn's body was recovered.
Next, Exhibit 9.
Yeah, again, that's just a closer photograph of the yard barn or shed with those items I described placed inside there.
All right. Did you participate in, or I guess, what did you all do with the items that were, that you saw located in that outbuilding there?
Those were obviously photographed and documented as what they were processed.
All right. Did you participate in that process, or were you just?
Yeah, I think primarily the two inside there actually searching, going through the items was Special Agent David Gratz and Investigator Tracy Arras.
Was that the end of your investigation, or what you did there on the property?
No, sir, it was not.
Okay. What did you all do next?
So we continued looking and led us to look inside the playhouse.
All right.
And we searched it.
And what did you find, if anything, upon looking in the playhouse?
There were, once the door was opened, right inside the door, as the opening of the door, was a trash can, like a tall kitchen model, a common trash can, and 2 bags of trash beside of it.
Agent Fairley, I'm going to show you a number of photographs and ask you if you can identify what's shown in those.
Yes, sir. The first one I'm reviewing is a standalone picture of what I described as the playhouse that was by. Okay. The second one is a closer of the playhouse, a closer proximity with the door open. The third picture is the same thing with the door open. Third one is a closer photograph with the door open. It does depict, the third one depicts the trash can with the bags of trash, as does the second one depicting the trash can. The first one, the door was closed. The next one depicting an open door with the trash bags and the trash can. The next one, assorted items that were inside the playhouse, and they appeared at that time. They had been there longer than the trash can and trash bags. Again, picture from outside the playhouse looking in where the trash bag or the trash can was. And it's a closer picture that depicts a black trash bag in the top portion of the trash can. The next one is a picture of an area inside the playhouse that had this assorted items there that, again, appeared to be there for some time with dust and cobwebs on them. Next picture is another picture from right at the doorway. Again, the trash can, the trash bags. Again, another picture of the trash can with the trash bag, the trash bags. There's other items around these. I keep talking about the trash bags and the trash can because they were relevant to us because they looked like they had recently been put there. These other items had dust and cobwebs and looked like they'd been there for years, undisturbed. The last photograph I have is this is my hand in the picture. It's pulling back. It's over the trash can with what appeared to be a leg and a foot of a baby or a baby doll. It appeared at the time with the fleece blanket and the purple onesie, the clothing that had been described to us by Megan Boswell.
When you made the observation that you made in the last, you described in the last photograph, did you do anything else with the trash can prior to the medical examiner's office?
No, sir. At that time, we didn't. We stopped what we were doing. We'd found we'd found Evelyn, and we made phone calls. We had called the DA's office, advising them that we'd found her. We've called our chain of command, our supervisors, and the medical examiner's office, along with forensic pathology out of Johnson City, and waited till all those personnel arrived.
Okay. And Agent Fraley, the photographs that you just described and identified, do they truly and accurately depict the scene as you saw it inside the Playhouse on March the 6th of 2020?
Yes, sir, it does.
Judge, we would move to introduce those as full exhibits at this time.
No objection.
The full exhibits on you went so fast, I didn't write it all down. Start with 10. I don't know where it is.
Ten through 19, Judge.
Okay. Judge, if I could, I'd like to publish those to the jury. All right. Agent Fraley, I'm going to start with Exhibit 10.
Yes,
You
sir.
would describe what the jury's looking at.
That's a playhouse that was located behind the yard barn.
And if we're looking at it that way, the outbuilding would be where?
The outbuilding yard barn shed is, as described, would be to the left out of the picture back this way from the yard barn or from the playhouse.
And the door, as we're looking at it, that door was closed when you arrived.
Yes, sir. That's how we found it.
Next, I'm going to show you Exhibit 11.
Same playhouse with the door open. And if you look inside the door right here, this white trash can is the trash can that I was describing as I was reviewing the photographs.
As you opened the door, was anything disturbed or moved, or, I mean, did anything shift?
No,
Is there
sir. Nothing fell out onto you. As you can see, there's a front porch there. It was opened, and it is as it's seen. Obviously, trash cans kind of tilted the way it is there, and the other items throughout the playhouse.
So the only difference between the prior photograph we looked at and this one is that you all have opened the door so that you could see inside. Is that correct?
That's correct.
Okay. Next, I'm going to show you Exhibit 12.
Same, obviously, playhouse, just from a different angle. You can see the trash can there on the left, and those two, you can see the main portion of one bag and partial portion, excuse me, of a second trash bag, two white trash bags there. Obviously, other items, the blue tote, the brown piece of furniture, and other items there.
Now we're looking at Exhibit 13.
Yeah, again, there at the playhouse, just a closer angle or closer photograph right inside the door.
You mentioned earlier that it looked like or appeared to you that some of the items had been there for quite a while, and that some of them did not.
Yes, sir.
Is there anything in that photograph that indicates that to you or that you can see?
Yes, sir. So the trash can and the 2 bags appeared to me that they had been placed there recently. The other items, like I said, the blue tote, those other things, these right here, that cardboard box, these items back here on the shelf, they just look dated and like they'd been undisturbed for quite some time because, again, they had dust and cobwebs located throughout the playhouse, except for that portion right there, right at the front door.
Now showing you Exhibit 14.
Yes, sir.
What are we looking at there?
Same thing. That's right inside the playhouse to the right. If you just stuck your head into the playhouse from the doorway, this would be to the right. And again, these items you can see specifically on this bag here. Well, a lot of these things, it's just dust covered, indicating to me that it had been there a while.
Agent Fairley, are we actually, if you're looking at the lower right-hand corner of the photograph, is that the door frame right
This
there?
is the right-hand door frame with the clasp for a lock. So yeah, again, like I said, if you were standing outside, just peering inside, that's kind of the angle or the view that's depicted in this photograph.
All right. Now showing you Exhibit 15.
Yes. The trash can again, this is taken from outside the doorway. This is me here. So the photograph depicts me, and then inside here, and the trash can with the black trash bag unraveled at that point.
Had the trash bag been pulled up out of the trash can, or was that
Just kind of like the top was opened.
All right.
The trash bag remained in the trash can, but the top was opened.
Now showing you Exhibit 16.
Again, looking inside, it was a very small playhouse. I don't recall the dimensions, but maybe 10 by 10, 12 by 12, a small floor plan with that. And then those were steps leading up to like a little loft inside that playhouse. Again,
This is
Another-
Exhibit 17.
Yes,
Sorry,
sir.
Go ahead.
Again, just another photograph of the trash can and the 2 bags. There's a keyboard there, a piece of furniture. Again, the blue tote. Just multiple pictures of kind of like the same thing, same angle, same point of view. Just multiple pictures of that. Again, the trash can again.
This is Exhibit 18. for
Yes,
the
sir.
record. Sorry.
Again, the trash can with the black trash bag inside the trash can, blue tote, other items there inside the playhouse.
Agent Fairley, there appears to be something on the inside of the white trash can. Were you able to?
Right there. Right there.
Okay. What is that we're seeing or looking at?
I can't see clearly what that is. I don't know if there's another
Okay.
piece of trash bag.
Okay. And Exhibit 19.
Again, after this was that black trash bag portion had been pulled away, this was the next layer down inside the trash can, which contained Evelyn Boswell's body, clothed in a pink fleece onesie with penguins and a gray and white fleece blanket.
All right.
What the portion of the body that you see there is her leg.
Okay. Did you in any way disturb or move or do anything with the contents of the trash can?
No, the glove in the top portion of that is my hand. Pulling that back to confirm and take a photograph. That was the only thing we disturbed,
Okay.
if you will,
All right.
to take the photograph. And then at that point we stopped and then made the appropriate phone calls to the medical examiner, forensic pathologist, our chain of command, and the DA's office.
All right, thank you. So what happened after you made those phone calls as far as the investigation was concerned?
So after that, like I said, all these people arrived, and our concern is to process the evidence. We did so at the direction of the forensic pathologist. And so what decision was made was on that front porch of that playhouse, which was just right outside the doorway, was to place a body bag there on the front porch. Open, they unzip and they open. So we placed a body bag there, and I brought the trash can out, and we started removing the contents of the trash can onto the body bag that was opened.
All right. And did you participate in that process with folks from the medical examiner's office?
Yes, sir. It was Laura Parsons, who works with the forensic pathology, and Dr. Matrina Schmidt, who is the forensic pathologist there.
And so you actually helped them and assisted them in removing the body from the trash can?
Yes, sir. Like I said, the body bag was there, and I removed the contents and the body of Evelyn Boswell onto the body bag where we could start processing what was inside the trash can, which additional evidence was in addition to the body of Evelyn.
And was this whole entire process photographed?
Yes, sir, it was.
I'm just going to stop that real quick, just to give us a little comment break. Unbelievable, y'all. Unbelievable. Like, this does not even seem real. Unbelievable.
Agent Fraley, I'm going to hand you some photographs and ask you if you can identify what's shown in those.
The first one is, as I just described, the body bag that's unzipped and placed on the front porch on top of paper. I think it was butcher paper we rolled out, but the first one is me removing the contents of the trash can, which included Evelyn's body. That's my arm in the top portion of that photograph. The second one continues that bag and the contents, Evelyn's body, being removed onto the body bag. The third one, the bag is out of the trash can at that point, and placed onto the body bag. The same contents, different angle, but it now has a evidence marker number 4 beside that. the trash bag and contents. Your Honor, if I need to slow down, I will. The next picture is the trash bag with me pulling back the trash bag, showing what's inside. That depicts a gray and white fleece blanket, and you can see where my hand is. It's a gloved hand. There's some aluminum foil there, evidence marker number 4. Again, a wide angle of the same thing once the trash bag has been removed. It's my hand there in the picture. It shows the body of Evelyn Boswell that's underneath these layers of items. That includes aluminum foil and the gray and white fleece blanket. You can also see some portion of the clothing. Evelyn was wearing the pink onesie fleece with the penguins. The next photograph is an opening of the trash bag that Evelyn was inside of, that shows different items in the bottom of that trash bag. Eggshells, fluids of human decomposition, and other items. That's my hand in the top, my foot in the top portion of that photograph. The next photograph is again the same trash bag with the contents that I just described, with the body of Evelyn to the right of that. That's going to be her head and upper portion of her body that's wrapped in this aluminum foil. The next photograph is just the body, again in the same state, with the aluminum foil, the blanket, the onesie. However, in this one with some body fluids that have come out onto the body bag, but there are also some pupa, that is insects, basically in between a larvae stage and an adult stage that were inside the bag as well. That's common with human decomposition. Next picture, same description, same things with that evidence marker number 4. Next picture, different angle, same description, the body of Evelyn, the aluminum foil, the purple onesie with penguins clothing, evidence marker with the insects there. The next picture, we start removing the layers at the direction of the forensic pathologist, the doctor. And this next picture is us removing the aluminum foil that was wrapped tightly around the head of Evelyn. And this is shows my hands and Laura Parsons' hands, who works there at the forensic pathologist office. Next picture, same thing. We're continuing to remove the aluminum foil from her head. So this is the first picture that shows the head of Evelyn and her upper torso, and her head is in a backward position, situated abnormally, where the body had been shoved, that we believe down into the bottom of the trash can. Next picture is same picture, body of Evelyn with the aluminum foil removed, showing advanced decomposition, some body fluids there lying on the body bag. The next picture is a same picture, the body of Evelyn wrapped in this this fleece blanket with the purple onesie, just a different angle on the body bag. Next picture, same thing, a different angle. And then the next picture is where, again, is describing how we're processing this, is removing a layer at a time. So this is a picture depicting the first part of removing the fleece blanket from Evelyn's body. And then the next picture, it's a black and white photograph with the fleece blanket removed and just showing the body of Evelyn. Advanced decomposition. Again, the pupa there, which was numerous of the insect activity. And then a color photograph, the last photograph, same picture of Evelyn's body and the pink fleece onesie there on the body bag with human bodily fluids around her head area.
Agent Fraley, the photos that you just described, are they a true and accurate depiction of the process that you all went through?
Yes, sir.
That night in removing Evelyn's body from the trash can?
Yes, sir. In the different stages of removing layers.
Judge, we would move to make those full exhibits this time.
Oh, Judge.
This first one, 20.
First was 20, I don't know what anything is.
Just to stop this real quick, it's Court TV that's put this block on here. On the thing it says Court TV will not show graphic images. So Court TV is the one that put that up there.
And there's going to be more serious things.
Yes. Well, yes. Yes. And Judge, I would ask at this time to publish those to the jury. I'll start with Exhibit 20. Agent Fraley, if you would describe for the jurors what they're seeing in this photograph.
So this is after we removed the trash can from inside the playhouse. Like I said, this is my arm, and it's the first stage of removing the contents of that trash can that included the body of Evelyn. Next picture
Now
is
looking at 21.
okay. This next picture is again the continuing process where the bag is almost removed from the trash can that contained the same items. That's my hand there, and the top portion of that, Laura Parsons' hand here, who's from the forensic pathologist department.
And now Exhibit 22.
Again, my hand and arm here with the contents of what was inside the trash can, same contents, the bag with containing Evelyn's body.
Exhibit 23.
This is the bag removed and placed. This is the body bag I explained with the evidence marker with me here in the background.
And at this point in time, the bag has been completely removed from the trash can.
Yes, sir, it has.
Now showing you Exhibit 24.
Yes, sir. That's my hand there, starting to remove or peel back that trash can or trash bag, and the first portion of removing that layer that shows again the fleece, the gray and white fleece blanket, and then over here you start to see the aluminum foil that had covered Evelyn's head.
All right. So just so that the jury is orientated as far as the photograph is concerned, Evelyn's head, as you all found it, is in the left. As we're looking at the photograph on the left side.
As we're looking at this photograph, her head would be right underneath where my hand is, covered in this aluminum foil. It's still inside the bag at this point.
Now looking at Exhibit 25.
This is just the first photograph of Evelyn's body outside the trash bag. The trash bag has now been fully separated from Evelyn's body. Again, the evidence marker number 4. This is my hand here removing and holding the bag. This would be her head on this side of the photograph with her feet on this side of the photograph. Again, as I've described earlier, the head was wrapped in this aluminum foil.
All right. And just so we're clear for the record, when you're describing the head, that's as we're looking at the photograph, that's on the left side.
Yes, sir, on the left. If you can see that pointer, that's where that's at, but facing that photograph, the head's on the left-hand side, the feet on the right-hand side.
To reconnect the judge.
It has, but it's just got your blue screen. It's not doing anything. Your laptop may have low battery. I don't know if it's plugged in.
I'll just use the Elmo judge.
Well, I mean, I've got the blue screen, but I don't know if it's, to me, it's not showing. You should see what I'm seeing on the thing. That monitoring account.
I'm just gonna use the elbow, Judge.
See, yeah, push it all the way, push it all the way. This is 26.
This is 25, Judge. Okay. I believe we got disconnected. Agent Fraley, you were describing, looking at the photograph. Evelyn's head is to the left where the foil is that correct?
That's correct. Looking as we're seeing it, the left here, this foil is her head, and down near the item marker number 4 is her feet.
Put your back to the elbow very top of the dog.
Showing you exhibit 26.
Yes, sir. My hand here. Another set of hands, Laura Parsons here. It's looking down into the trash bag that that Evelyn's body was pushed down into. And like I said, there is just assorted trash, eggshells, human decomposition fluids. And then on the right hand portion in the lower section here is that aluminum foil and the blanket with the body of Evelyn right there.
And that's right after you all had removed the body from the trash bag.
Yes, sir.
Now showing you exhibit 27.
Again, a similar depiction of the last photograph, just it's a wider angle that's kind of showing the aluminum foil that's full, kind of formed around her head with the rest of her body there, down to probably about her upper torso. Again, here talked about the aluminum foil head again, the rest of the body. Right here's what I'm describing as the insect activity of mid stages of pupa. That is basically in between the larvae section and the adult section of the insect typical as flies.
Now looking at exhibit 29.
Again, just a different angle of Evelyn's body that's underneath these layers of aluminum foil, fleece blanket, down to her clothing, the purple fleece onesie with the penguins. And
At this point in time, you all have not removed any of the items from the body. Is that correct?
no, sir. No. Again, what we tried to do at the direction of the medical examiner and forensic pathologist was remove these in layers. As you see, that's each picture's best we could do is a layer, taking it through the trash can to the trash bag to the aluminum foil to the fleece blanket down to the purple onesie.
Now looking at exhibit 30.
Again, this is kind of just stepping overhead, looking down, same photograph, Evelyn's body with the foil and the fleece blanket and the evidence marker number 4.
Now exhibit 31.
That's the first, again, as I've described, taking this by layers. So this is us removing the aluminum foil from Evelyn's head.
And if you would, describe for the jury the processing. Was this a difficult process? Was it easy? How was the foil attached?
The foil was attached. It was compressed. It never occurred to me that when the body of Evelyn was placed or forced or shoved into this trash can, that this was a piece of foil that was just kind of put on there. This appeared to me to be formed around her head with the contours of the face, the eye sockets, how they're concave. this was formed. It wasn't just happened to be there and the body of Evelyn placed there and it just happened to meet up. It was formed.
So did it take you all a while to remove the foil from the body?
Not long, no. Like I said, once we got there, Laura Parsons and I separated the layers, as you can see depicting in these photographs. And that's as far as we went. Once we got I think the next one will be the fleece blanket. But once we got to the body of Evelyn in her clothing, which was this purple fleece onesie with penguins on it, we stopped, and I'll continue at that point.
All right, I'm going to show you Exhibit 32.
Right. Again, this is just the next step, continuing to removing that foil from Evelyn's head.
Okay. And at this point, it looks like you all have essentially removed all the foil.
Yeah. Yes,
around her
sir.
head.
Yeah. It's off of the head and being pulled away by Laura Parsons.
Now I'm going to show you 33.
Okay. Now this is a photograph of where we're at with the processing with the aluminum foil removed from her head. So this is her body with the next layer, which would have been that gray and white fleece blanket. Again, what I described earlier, this here appeared to us to be this fluid here was just bodily fluids of human, consistent with human decomposition.
It's somewhat kind of tough to tell because the way it's spaced there, but is the blanket up there, is that around the head as well?
So the head is here. This is her right arm. She would be facing to the top portion of this picture, but her head was in a manner that it was backwards. It wasn't normal as I'm sitting here or you're sitting here. It was backwards, and that's hard to depict here, but her body in this photograph is facing to the top of the photograph with her head tilted backwards toward the bottom of the photograph. That's her right hand right there. That dark portion out of that fleece, that purple fleece onesie, and the color is very dark because of the advanced stages of human decomposition.
Now showing you Exhibit 34.
So again, this is the same stage in that, where this is on the other side of the body, this being the head, this being the hand that I just described, the pink, purple onesie with penguins, and the gray and white fleece blanket.
All right. And again, from this angle, are we looking at the blanket there pulled up around the head?
Yes, sir. It's covering like it had been pulled up and over the head. So that is the head on the right-hand side of this photograph, with the feet on the left-hand side of this photograph.
Now showing you Exhibit 35.
This is, again, same Evelyn's head on the left this time. Her body facing to the top of this photograph and starting to remove the gray and white fleece blanket from her body. This is her leg down here. That's like the foot in a onesie that has those treads, so they have traction when they walk. So that's going to be her right foot and right leg on that.
And now showing you Exhibit 36.
Again, that's the next picture of the removal from the of the fleece blanket, the gray and white fleece blanket with her body there. And you see, again, it's going to be her right arm there and her right hand right there.
Now showing you exhibit 37.
Yes, sir. This is a black and white photo, obviously. Her facing the top of the photograph. This is her right hand. Again, even though it's black and white, it's the consistent with the pictures you saw on the purple fleece onesie with the penguins. And this is her head to the right side of this picture.
As we're looking at that onesie, had it been disturbed, or does that show the onesie as you all?
That's as we finally removed the fleece blanket. That's the next layer as we found it.
Okay, so the onesie was open.
Yes.
And, sorry, hold on a second. Now I'm going to show you exhibit number 38.
Again, this is the body of Evelyn. That's her head. There's her legs and feet. There's her right hand there on that body bag.
If we can, I'd like to go back. I'm going to show you exhibit 37 again.
Okay.
I don't know if it's
The black and white
yeah, it's
photograph.
black and white photograph. Which is, as we're looking at the photograph, where is Evelyn's face? As we're
So this is her head on the right-hand side of this photograph. Her body is facing to the top of the photograph, so her face would be right in here on the back side of, kind of looking at the back of her head. Again, it's advanced decomposition.
and the fact that there was advanced decomposition, did that affect your all's ability to be able to, or how you were able to process the scene there?
Yeah, I mean, like I said, in conference and at the direction, the medical examiner, the team from forensic center there. Once we got to this last picture where we were at, the call was made, hey, we're going to stop here. We'll seal her body in the body bag, transport her to the forensic center for an autopsy at that point. And we continued processing the scene there for collecting the items. And we took those items to the Sullivan County Sheriff's Department, just where we had better lighting, better environment to log and process evidence items that were also discovered.
You're going to go from one set of photos to another set of photos?
Yes.
Just to leave that thing.
Okay.
Because when you put it down, the electronic disconnects from the system. There's a lot of delay.
Agent Fraley, you described the process of, I guess, taking the other items, the trash bags that you recovered from there, removing them from the scene and then taking them to the sheriff's office. Is that correct?
Yes, sir.
Okay. I'm going to hand you a series, I believe it's 6 photographs, and ask you if you can identify what's shown in those.
This first photograph is a picture looking over the top of the trash can, looking down in it. And the bottom of that, the most notable item is a Martha White chocolate chip wrapper with other items.
Was that the trash can the body was found in?
Yes, sir, it was. The next one is a photograph of the trash can with Evelyn still in it at this time. This was an earlier photograph taken prior to the removal of Evelyn and the trash can. What's important and noted here is a piece of chewing gum that is attached to the inside wall of the trash can. The next photograph is after I removed the trash can and the trash bags from inside the playhouse and just set them out on the porch of the playhouse prior to going through the pictures we just looked at, processing the removal of the layers leading to the body of Evelyn. Just another picture, trash can. Evelyn still remains in there. You also see the chewing gum on the inside wall of trash can there, and the other bags of trash. This next one is the 2 bags of trash that was removed from the playhouse with the trash can. Another angle of those 2 bags of trash that was removed from the playhouse there on the front porch of the playhouse.
So were there any other items besides those 2 bags of trash and the trash can that were taken out of the playhouse?
Not that I recall. It was all the trash bags and what remaining contents of the trash can.
Okay. The 6 photos that you just described and identified, do they true and accurately depict those items as you found them on
Yes,
March
sir.
the 6th, 2020?
Yes, sir, they do.
Judge, we would move to introduce those, I believe, exhibits 39 through 44.
Go, Judge. Before exhibits 39.
Not asked to publish those to the jury at this time, Judge. Agent Fraley, we're going to start with exhibit 39.
Yes, sir. Again, top view looking down into the trash can. And like I said, the most notable thing that's descriptive is a Martha White chocolate chip cookie bag.
Anything else in the trash can besides that on the bottom?
I mean, there's...
Is that what was found when you removed the trash bag?
Yeah, so once we removed the body of the trash bag that contained the body, this was in the bottom of that.
Now showing you exhibit 40.
Yes, again, a top view again of the trash can that shows the fleece blanket and chewing gum there on the inside wall of the trash can.
And if you would just kind of point out or use the
sorry,
laser
yeah.
pointer to show what.
Yeah, so this right here, it's a piece of chewing gum that was removed, collected as evidence, and sent to our crime lab. And again, there's that fleece blanket that we've been going through earlier.
All right. So that was taken before the body was removed from the.
Yes, sir.
Now showing you exhibit 41.
Again, this was prior to processing. This was just simply removing those items. That includes the trash can and these 2 trash bags from inside the playhouse. That's prior to laying out the body bag and removing the trash bag with Evelyn's body onto this front porch. But this is where all of that was processed in the field prior to transporting Evelyn to the Forensic Center for autopsy, and prior to collecting, processing, bagging, and packaging the other items to go to our TBI lab for analysis. Again, same
Exhibit 42.
yes, sir. Same picture or same items, just different angle. 2 trash bags, trash can.
And again, that was taken before you all had.
Yes, sir.
Exhibit 43.
Just the 2 trash bags with the trash can out of the view of this particular photograph.
And finally, exhibit 44.
Again, just a different angle of those 2 trash bags without the trash can in that photograph. And both of those were, like I said, were on the front porch of the playhouse.
And those 2 trash bags, you all, when I say you all, I mean law enforcement took them and inventoried what was in there
Yes, sir.
later on. Is that correct?
Yes, and any evidence that was collected that we believe to be probative was sent to our lab for examination.
Agent Fraley, I know you did and you've described a number of different things that you did in the course of this investigation. Did you personally interview Ms. Boswell during this whole process?
Yes, sir, I did.
And in the course of your interviews with her, at some point in time, did she make a statement to you in which she finally admitted that Evelyn, in fact, was not missing, but was in fact dead?
Yes, sir. On February 25th, at the Sullivan County Sheriff's Department, Sullivan County Sheriff's Detective Jonathan Licklauder and I interviewed Megan.
Okay. And at that time, she told you all that, in fact, Megan was deceased. Is that
Yes,
right?
she,
Okay.
that among other things as well.
Okay.
Yes, sir.
During that interview, did she describe or give any description of the clothing that Evelyn was wearing?
She did. Described a purple fleece onesie with penguins on it that she was clothed in.
Okay. Did she describe anything else that was with the body or with Evelyn?
Yes, she had stated she had wrapped her in a dark fleece blanket.
And how did you, I know we've seen pictures, but how did you find Evelyn? What was she wearing and what was
Those
she wrapped in?
exactly what Megan had described to us for the clothing and the blanket.
Thank you, Agent Fraley. If you
Yes,
would
sir.
answer any questions, Mr. Scott or Mr.
Jury's lunch is here, so we're on break. We'll be back at about 1:15. So ladies and gentlemen, I'm gonna have you go with the court officer.
Let's stand, please. Be seated. Now, I've also got information that the witness that in question is out in the lobby. Do you want me to bring him in and give him a bond? Otherwise, he'll be in custody of the sheriff. Because the order didn't have a bond set.
I would prefer that. I'd also ask, we instruct him to talk to us before, I guess. Well, okay. I mean, otherwise I'll just ask that he be held without bond.
I don't care what you do with him, but I don't think it's the court's purpose
Okay,
to
well, that's,
tell a witness to talk to someone or not.
Okay, that's fine.
fine.
that's fine. That's fine, Judge. I'll tell him.
You want it brought
I
in.
can tell him if he doesn't come back, if I don't come back, that he'll be held.
Yeah, that's fine. And
Yeah, bring him in.
You want me to step down, Your Honor,
Yeah.
to provide this for him?
Don't discuss the
Yes, sir.
rules of office. You can't discuss this with any other witness or allow them to discuss their computer. What's his name? I don't have to work.
Austin Felder.
Last name?
Feller, F-E.
Feller, Feller.
Mr. Keller?
Yes, sir.
You were served with a subpoena in the court Monday, and you didn't come, which is why we're here today with you in custody. I'm going to set a $500 secure bond. You can make that through a bond company. You are a material witness in this case. What happens if you don't come back to court after you make that bond? And you are now instructed by this court that you will appear at this court no later than 9 a.m. every day except Sunday. That includes Saturday. Until you are either called as a witness or released as a witness. You understand that?
Yes, Your Honor.
If you fail to do that, and we have to come find you again, you'll be held in custody of the sheriff with no bond until the case is over. And that could take us about 3 weeks. That way we know where you are.
Yes, Your Honor.
You need to be here back at 1:15 if you make that bond.
Yes, sir.
You go. Jim, if you don't mind now, if you don't mind, just sort of set the whole test. All right, we'll be back at 1:15.
Court stands in recess.
Judge, I wanted something with a bond on it.
Did you guys remove your mic from your check?
I got sent back off because I thought we were cutting our mic off.
Okay, so I guess they are going on lunch. I don't know what time it'll be back. Anybody know who that boy was? I saw somebody, Cinnamon said, well, look who it is, my. Pause that. Well, he's a witness. So, whoever he is, they'll tell us whenever he gets up there. I just didn't know if that was if that was the baby's daddy, or a family member of Megan's. They said 1:15. Okay, so I wonder what we should do. Should we just wait and keep it going? Or end this one and then start a new one whenever they get back. What do they usually do? Anybody know? I forget. I think this is just awful. That garbage can was just a regular kitchen 30-gallon garbage can. I think you guys are right. And that was unbelievable. I just can't even imagine that little face there on that picture. It's awful. Some channels wait, some do a part 2. Well, it was pretty tough to take. Bugman, I agree. This whole thing is, and you know, we could look at this and say, man, this stuff's happening more and more. But I don't think it is. I think this kind of stuff has happened for, well, thousands of years. It's just with social media now, more of these cases are getting out. Lois says, funny how she said the baby looked like the dad, and that wasn't even the dad. Oh gosh. It's just, I could never be a policeman. I feel the same way. I don't know how. You know, I give a lot of criticism to a lot of police officers and prosecutors, and a lot of them well deserved. But in the last few days, I've seen a couple, like where I watch those body cams and stuff, and in real life, I've seen a couple good, patient, confident. They weren't insecure. You know, they were the way that they communicated with people. And we're talking about crimes that have been committed, like shoplifting or stealing or, you know, whatever. But every time that they would sit down and do the interview, the ones that I'm thinking of in my head, they were just real confident, but they were kind. They weren't bullies, you know, and they treated the person, even though a couple of them had done horrible things, those officers still were able to disconnect from their emotions. Like they didn't come across with attitudes. They didn't act like, you know, they were out for revenge. I don't know. I just think that to be law enforcement, they really need to have special gifts with being able to communicate with people. You know, you don't want bullies as police officers. You don't want real aggressive type personalities that are going to get that department hit with tons of complaints and lawsuits and cost the taxpayers a big bunch of money just because you wanted to be a tough guy. But they also have to be strong enough and clever enough to get the bad guys. I realize that some people you can't be kind and good to. But I don't know. It's just awful, y'all. It is absolutely awful. Jessica says it gets more publicity. And Miss Myrtle, hi, honey. Jet says, I believe it is getting worse because of prescription, head meds, and illicit substances, plus the general degeneracy and decline of morality and responsibility. Well, yeah, and I think too that back in the early 1900s, all the way up through like the 60s, and even into the 70s, you still had a very traditional home environment in most cases. It was more traditional. People tended to stay married, for the most part. I mean, you did have divorces and stuff, but a lot of people stayed married. And for all different kinds of reasons, women didn't work, as much and whatever. But I think the decline of the home life, children were meant to have two parents, a mother and a father. And both of those roles are very important. Like my home, my kids don't have a dad in the home, so I'm speaking from experience. I come from a broken home. But I think in maybe the 70s and 80s and 90s, maybe even down into the 60s and 60s, you started to see more divorces. You started to see more broken homes. And so you also saw more single mothers, or single parents. And I think that has a lot to do with it. I think that has a whole lot to do with it. Because a lot of time back then, I think you had more grandparents maybe too that were involved in more of a home life. I think the world's just changing. Now a traditional marriage is not the norm anymore. Kathy says, my kids had 4 parents, but the one thing we all agreed upon was that we would work together no matter what for the sake of the kids. Oh, yeah. I get along really well with my boy's dad. We've co-parented very well. They've never stayed with him though, but we get along really well. I think when children have to hear the animosity and the fighting and the bickering and the jealousy, and especially if they're young. I'm old now, I'm 48. I don't have any, and I don't have a partner, so I don't have any of those fights to go through every day. Whereas I remember when I was a kid and had a stepmom, when you have blended families like that, a lot of times you end up having a lot of fights. There's a lot of jealousy, or maybe they have a red-headed stepchild, or they're treated like a red-headed stepchild. It's just awful. I'm reviewing the investigator's testimony. My cats are about to tear my house down. They usually do this at night when everybody turns TVs off and goes to sleep. And tries to go to sleep. They run through the house like it's crazy. Crazy. It has become a disposable society. It's easier to toss things and replace them rather than to fix them. Man, you hit that right on the head. And how many disposable children are we seeing? You know, a lot of men. I don't want to say just men, but a lot of people. They get in relationships. They have children in these relationships, and then they break up, and then they move on with another relationship, and the grandparents end up with the kids, or maybe one of the parents ends up with the kids, and then they move on in a new relationship and have more kids, and then they break up and move on to another relationship, and then they've left all these kids in their wake that have no parent because they've moved on to another relationship. Yes. Hello, Carm. Number 2. Welcome, welcome, welcome. I think we're just going to leave this going. I don't think we should close it out. And everybody can just come back whenever, if they want to go away and come back, the stream will still be here. The decline of the 2-parent family has caused many a boy running things as teens, doing what they want because no one's at home, no one to stop them. That's right. Latchkey kids is what they call them. Maybe from a single parent household, that the parents always working. So when the kids get out of school, they have this window of time between the end of school and, bedtime, that there's nobody home to supervise them. So they end up in the streets, they end up with their friends, they end up seeking out some type of acceptance and community. That's one reason why I started my kids in ball when they were little. Now that's something I did get from my dad. My dad always had my brother in ball. And I saw how I don't know, I guess that was just an exposure. But I took it and made it a goal and a lifestyle with raising my kids. Started them in T-ball. So they were like, 3 years old out there hitting a little ball with a little bitty waffle bat or something off of a tee. And so they did that every year. And then we did pee-wee basketball. Started them off in like first grade or kindergarten, whichever one it started in. And so they did pee-wee basketball every year, T-ball, and then they did flag football because they had to do flag before they could play tackle. Tackle started in 3rd grade, and so we just rotated with the seasons. We rotate with the sports. And it's just been great. I have a friend who also has a couple kids in sports, and her son has ADHD, and he struggles with something else too, but he's a great athlete. Baseball is his sport, and it lets him get all of his energy out. He it helps him to focus. It it's really been an amazing tool for them as a family, because it gives him routine, it gives him structure, it gives him that consistency that he needs, or, you know, that he thrives in, considering his disabilities. And that's the same for all of us. Every single one of us. I know I've got lots of things that that it helps me with, you know, just in my own crazy mind. As a ball mom, it also gives me that structure and that routine. My children, just getting them up every day and going to school, that's and then having practice every evening and work, you know, I also have structure. I also have a routine. I also have a consistency because of my kids. Having to support them, having to provide for them and survival. So now you've got a whole bunch of people who, you know, the other night when we was watching that city council meeting and that lady was wanting money to help put a homeless shelter or whatever, you'd end up with a whole lot of overflow that you couldn't take care of. Because we've just got so many people who are on rugs and who just don't want to get on their feet. And it shouldn't be somebody else's responsibility all the time to get them there. Miss Kathy says, I was the mom that got thrown out of all of the T-ball games because I yelled at the coach for making my daughter cry. I love it. I love it. Yeah, that's what we're going to do, Miss Marnie. We'll just leave it open and everybody can come back. Yep. Mountain mover. Courts play a pivotal role in determining critical family matters, such as whether a non-parent can secure legal guardianship over a child. Yep. Single motherhood was glorified in the 90s. The fathers are missing, and the fathers are supposed to be the protectors and the providers. Yeah. Genevieve question, who discovered the baby's body? That's a good question, Genevieve. How did the papa know to call the police and tell them that he thought the baby was in the playhouse? Taking spankings out of schools did not help one bit. I remember, yeah, our teachers had paddles that had holes in them, and then they wrapped them with black electrical tape, or I've seen them wrapped in duct tape. They tell you to bend over and hold your ankles. It was rough. Kathy says, I think working in family law helped me understand that we needed to work together, even though we couldn't stand each other. No arguing in front of the kids. Absolutely. My dad and his entire family just, eviscerated my mom when I was growing up. Anytime I was there, that's all they did was talk bad about her and put her down. And, you know, kids, what it made me do was think that I just needed to hate her as much as they did. Because if I hated her as much as they did, then maybe he would love me more. And no, that don't work. But that's a child's mind. When you're a little kid, that's how your brain, or that's how my brain worked. And I didn't realize it at the time, but now being able to, analyze this stuff, I can see that now. That's what I thought, in my mind, some crazy way. If I hated her as much as they did, then he'd love me more. And he didn't. He never did. All it did was turn me against my mom for a long time as a kid, and then you'd end up, and then they'd ship you right back to her. So after you'd spent a whole summer up there hearing all this stuff, just awful about her, and then they turn around and hand you right back to her. So then you'd go and have to live with your mom during the school year. Oh, it's just awful. And then you fight and fight and fight. Mother and 13-year-old girl. Fight. It was awful. It was awful. And a lot of that I blame on how much crap they talked. Because children, even though you're talking about their parent, that's still, kids know that they're half of their parent. So if you're talking about that other parent, they're still half of that other parent. So they're going to internalize that and think that that's what they're going to end up being. I don't know. It's crazy. The psychology of a child, of an undeveloped mind, is very dangerous. And we just don't realize the damage that we do to our babies. All because we can't keep our mouth shut and say something nice about somebody. Not everybody's perfect. That's for sure. Let's see. All professionals have good and bad in them. Absolutely. We all do. All people have good and bad in them. That's for sure. Jessica, I may be controversial here, but I think participation trophies are part of the society's problem. If you're going to get rewarded for doing nothing, why strive to be better? Yeah. Yep. I was the mom that helped the moms who got kicked out get back in. You've helped them walk it off. There you go. And you end up becoming like a little family, ball parents. You get real close to each other. Your kids are all real close, and you end up watching these kids grow up. See, I'm just now able to have this kind of exposure in life as a ball mom. When I was a kid, in 11 years of school, I was in 13 different schools. So I wasn't never able to stay in one place for very long to where I could make friends and, play ball. And I sure didn't have nobody that was taking me to practices and stuff. I mean, my dad did a little bit when I went up there and stayed for a couple of years, but we fought and had so much drama and trauma all the time. My kids playing sports and me being able to just realize how important that was and how important it was gonna be. It was it was actually a certain type of discipline that I had to develop in myself that I'd never had before. And it's worked. It's absolutely worked 1,000%. I couldn't brag on my kids no more than they are just really, really good kids. They don't get the best grades. And we always end up having to do their makeup work so they can stay eligible for ball. Because we miss so much school in the wintertime. But like NTI work and stuff, would hurry up and get all that done. They're not the best grades. They don't get the best grades. And they're not the best athletes. But they sure give everything they've got. They give it everything they've got, and they always have. And that's the one thing that I've just always asked them to do. Just go to school in the morning and go to ball practice. That's it. I don't ask you to do nothing else. If you do that, I will feed you. I will clothe you. I will keep a roof over your head. And I'll be the very best mom that I can possibly be. If you'll do just those two things. Go to school, get up, go to school in the morning, don't give me a hard time, and go to practice in your ball games. And they always have. Always have. And they're really good. Like, it feels good to have other parents come up to me and say, you know, I saw Alan the other day and he was helping this student, or, you know, they brag on him. I don't ever have anybody come up to me and say, hey, we saw Alan the other day downtown and he was up to no good. I've never heard that. No. Never. The scariest thing in the world when I was a kid was my grandma telling me to go get a switch. Yeah, they do. Grandma, they make you go cut your own switch. Is mom feeling better today? No, not really. She went to the doctor. I don't know what's going on with old Zelmy. But she's having a rough time. So pray for her, please. We never badmouthed the other parent, although I would have loved to. When they would ask why we weren't together, I would tell them when they were adults, we would discuss it. There you go. I did the same. Mine asked me why I didn't hate their dad and family and talk bad about them like they did me. Oh, my dad's family talked awful about my mom. They talked awful. And I've seen that as an adult. Whenever two people split up, the families just absolutely, you know, when you break up with them, you also break up with their family. Whether it's deserved or undeserved, it just seems to happen. I don't know why. Can we ask folks if anyone wants to be a digger or a bloodhound, or if anyone wants to learn how to file information requests? Absolutely. So if anybody is interested in helping us with the channel, and you would like to be what we call a digger or a bloodhound, let me pull up my list here and I'll read it off. Okay. So these are the HBIC rules. So I'm the HBIC. That's the hillbilly in charge. We put a new little play on the the HBIC. All right. Admin is me and mom. Let's see. HBIC are paid YouTube memberships or show sponsors. Mod is the moderators. Coaches are mentors and refs. Diggers are researchers, deep dive backgrounds. Bloodhounds are finding stories to cover. Clerks are official documents and information requests. And so that's what we've got listed for now. And so if anybody would like to help with the channel, send me an email to hillbillycrime@gmail.com and let us know what you're interested in helping with, and we'll put you to work. We will absolutely put you to work. Thank you. Jessica says, I told them that I wanted them to make their own choice, and once they were older, they would understand more. Yep. We stressed that to our clients because it was only hurting the kids. It sure does. I'm proof positive. I'm the damage that it causes. Oh my goodness. Saved by grace. I lived with a grandmother that had been a foster mom since the early 1900s. When I say old school, that was her, but she had a generous heart. Oh, good. Vicky says, I grew up in a very united two-parent home, and there is a great comfort in that. Bless you. Yep. Count your blessings, Miss Vicky. Absolutely. Count your blessings. You know that story of the little girl up in New York or New Jersey? The one whose tattooed daddy, she was kidnapped, and her daddy is like tattooed on his face and everywhere. He's a great big muscle, like he's kind of scary looking, like he just got out of prison or something. Face all tattooed up. But his daughter was kidnapped, and he was the one investigating it along with the police, but he's the one who went out onto the yacht. He found the big boat they were holding her on, and he went and kicked the door in, I reckon, and saved her, rescued his own daughter. And now they're arresting all different kinds of people. There's a lot more than just one person been arrested. And that was what I used to do to myself. It was just so self-destructive. I knew my daddy wouldn't even walk out and get in the car to come get me, let alone knock a door down. When I was out somewhere. But that's what I would always do to myself. And I didn't realize I was doing it at the time. But I'd put myself in these really bad places, just really bad positions, and just to prove to myself that my dad wasn't coming to kick the door down. I mean, how stupid is that? But the psychological damage that children go through, man. And I was a young adult at that time. But I would just put myself in these really bad positions just to prove to myself that he wasn't coming. And he never did come, of course. But when I saw that story about that daddy that went, and he actually did go kicked the door in and picked her up. That's what I imagine in my mind when I was young. I can remember I'd actually be somewhere and I'd look at the door and I would imagine it in my head, the door coming off the hinges and my dad coming in and scooping me up and, rescuing me and taking me home. Rejection will sure tear little girls up, y'all. Megan's father had begged her to put Evelyn up for adoption. He said, "There's no way you can handle a child." Well, he was right, wasn't he? How could this have been prevented? Evelyn does look more like her daddy, Marnie says. I noticed they'll be taking her BP often lately. Hope she feels better soon. Yeah, I know. I saw her doing that too. Evelyn says, "Hi, I'm really sick." Well, we'll pray for you, honey. Pray for a healing, fast healing. God sure did heal me. I can talk about these things now because I have received that healing. And it was only through my own relationship with God and my kids. My kids were what gave me that drive to do better and be better. Definitely both parents are very important for kids as well as grandparents. Absolutely. They all play a role. They all have a role, even siblings. Tennessee accent is a lot like our hillbilly accent. It sure is. Yeah. My paternal grandparents were huge influences on me. I was very bonded to them as they fed me and helped take care of me as a newborn preemie. Oh, yeah, I was real close to my grandma too. And that was my dad's mom that I was close to. I didn't know mom's mom. If you join Discord, we can help you learn how to find information. Absolutely. We're going to have like a meeting where we'll go in and we'll all go into a room or a thread or whatever it's called on Discord. And we'll figure out how to do information requests. Elizabeth sent me the Discord link, but it expired. Oh, okay. Sorry. Yep. Mama Duck, if you don't care, send me a new Discord link. Thank you. I have seen a story about a mama who wiped out half a gang for red rum and her child. Hey, I'm telling you. Yeah, we all want and need both parents. She wore disguises and went undercover to get them. I saw that, Jessica. I was all right on Mama. Yep, I remember. I saw a thing on her. It was a long time ago though, but I remember it. Girl, it's not stupid. We are products of our environment. You were trying to have what every child deserves, but now I bet you're the person you needed. Yep. Hey, I'd sure go kick that door in for mine. I tell mine all the time, and I tell their friends too. You can tell me anything. Tell me the truth. So that way, if I have to lie for you, I know what to do. I know what to say. No. I wouldn't lie about nothing big. But I can't say I would never over something small. I don't know. But still, you got to tell me the truth. So that way I know I can decide what to do. But if you tell me a lie, then I can't help you in no way, shape, or form. And you can always call me at any time, and I will come get you. Yeah. It's 12:40. I'm going to take my dog out to potty and stuff. And I will just meet you all back here whenever this goes back on, okay? And we'll pick back up on part 2. Baby Evelyn. All right. See y'all in a little bit.
What do you think of
No, it's not. Probably gonna lose on that. That's unfortunate. Fair to tell you that portion of the place for 2 years, that should be told. Tommy's convictions are 2 years.
Oh,
Didn't have trial. Can't have trial. One of the issues that came up when the state dismissed one count of the indictment, and asked that prior to me cross-examining or asking Mr. Fraley about any statements that Ms. Boswell made to him, that I bring that up outside of the presence of the jury. Since then, it's my position, unless I misheard something, I think Mr. Harper questioned him about statements that Ms. Boswell had made to him. And I think that opens the door for me to be able to cross-examine him about the statements that were made as a doctrine of completeness. You can put in part of a statement, the whole statement.
Judge, I didn't listen to any testament about what she said.
You asked if in a statement to him, she ultimately admitted that the child.
Okay. But I mean, for him to listen, I mean, it's self-serving hearsay. I mean, it's,
Well, I had 6 statements.
well, there's no written statement.
Once
There's
they,
no written statement.
it's recorded, it's 2 hours long, it's thereabouts. But once they ask, I think I'm entitled to ask about the entirety of the statement. I think that's the law. It's called, the court's well aware, it's the doctrine of completeness. The case law is complete with it.
Judge, it's hearsay. I mean, just it's flat out hearsay for him to try to put that in.
It's,
It is Tennessee. Tennessee people are kind of crazy about their orange, the same way Kentucky is about their blue.
All right, and looking at the newest edition of Tennessee Law of Evidence, 7th edition. I'm on page 8-6. Under Rule 803, 1.2, admission by party opponent. A statement offered against a party that is the party's own statement is not excluded by the hearsay rule. And in the entirety of 806, I'm sorry, of the discussion of Rule 803, 1.2,
Hard to say it, it's just,
well, in the book, it's section 8.06. But the rule is actually 803, 1.2. There is no discussion of the rule of completeness as applied to the exclusion of a party opponent admission. The only thing it says is that the person against whom the statement is used may testify. And of course, this is a criminal case, so she's not required to testify.
Judge, did the court refer to Rule 106, Rules of Evidence? I think that discusses the doctrine of completeness and the process of pulling a case. The case of State versus Torres from
Hold on.
Tennessee.
This is why we have these issues. That's why I said so many hearings before court.
I understand. I didn't expect they would dismiss that count of the indictment today, not and do this.
One what?
106, Your Honor.
Jim, do you have
I'm sorry? And that is state versus Brewer.
So, under a 106 evaluation, what, I guess the question is, I don't know what the rest of the thing says.
Well, that's exactly my point, Judge. There's nothing misleading about what I asked. I didn't ask anything about what Ms. Boswell said. I didn't elicit any testimony whatsoever about a statement that she made. All I asked was whether or not she admitted that she was dead. There's nothing misleading about that, and nothing about what he's going to ask as far as that. All it does is further their theory. It doesn't in any way clear up any misconception or misleading information that I may have presented from that.
According to this Torres case, in 2002, in the defendant's murder trial, the court erred in denying the admission of the videotape of defendant's statements. However, the error was harmless because the evidence of the defendant's guilt was overwhelming and nothing on the videotape remotely implied that the defendant was innocent of the crime. So, not knowing, I don't know what's on this tape. I haven't seen it. Today, hearing about it. So that's what I'm asking.
Judge? My understanding of that doctrine, it doesn't, I don't have to show that there's something misleading.
That's absolutely, he does. I mean, it's right out of the,
Can I finish? I'll listen to you. I mean, no disrespect to anyone here. I'm not trying to upset anyone. But in Torres, there was an issue about that. There are other cases besides Torres. That's the first one I pulled up. There's a State versus Brewer where it's the same thing. It's an issue of fundamental fairness. They ask about the statement, then they say, I can't ask about the parts I want to ask about. And if we need to take a minute, I'll ask the court for a minute so we can print a couple of those cases and make sure I want to do this right. I know you want to do it right.
You've got the cases on that.
Judge, I think there's a good explanation in the unpublished case of State versus Dylan Brewer. That could be found in 2019 Westlaw 1109917. I forwarded that to your assistant and asked her if she would print it. I have not. And I've given that citation to the state as well.
And Judge, I would go back to the part, the rule requires that a writing or recorded statement or part thereof be introduced by a party. I did not introduce any part of her statement. I asked Detective Fraley if she ultimately admitted that her child was dead. I didn't ask what she said. I didn't ask how she did, if she did it, if she admitted she did it, if she said she didn't do it.
What you asked was if she made a statement to you, in which she mean, I heard them back. If that's what you want me to do, I mean,
I would further point the court, the footnotes to the rule of completeness 106 clearly talk. Mr. Scott said it didn't, but it clearly says, rule providing that when a writing or written recorded statement or part thereof is introduced by a party, an adverse party may require the introduction at that time of any other part or any other writing which ought in fairness to be considered contemporaneously with it, provides an adverse party a mechanism for putting portions of the writing into context if the portions would otherwise be misleading. There's nothing misleading about what I asked Agent Fraley. He's not trying to clarify anything. Unless he's in some way trying to insinuate that the child wasn't dead.
well, we're gonna take a minute, I'm gonna look at whatever cases.
Did you get that? Did you find it?
Yes, Judge, they're having a hard time going through it. We can have a minute, I'll collect and send them back. Yeah, I just may need time to do it. Back to your staff.
Your Honor, may I step out for a few minutes?
Yeah, we'll take, we're still on,
I'll just unmute myself and say it instead of typing it in the chat. I thought that was fingernail polish remover on her desk there for a second with the pink lid. I don't know what that is. That might be lotion. Yeah, they're muted. Depending on how smart these lawyers are, I think that will determine how this trial goes. Because if you have a really well-educated defense attorney who knows what they're doing, makes for a better trial. I thought in was it Rittenhouse, that boy's name, Rittenhouse, the prosecutor in that trial, in that boy's trial, he was like, he didn't even know the law. He did things that were just, the judge reamed him good several different times. He did things that he should not have done. He wasn't allowed to do. He should have known he wasn't allowed to do. Blatant arrogance and disrespect right in the courtroom to the judge. I don't like seeing prosecutors like that. But sometimes those prosecutors will just bulldoze right on over defense attorneys. They ain't got much of a defense. They ain't got much of a case to work with. But we all know it takes money to get a good defense attorney. Cheaper is not always better. Cheaper is not always better. Said the court security guy over to the left is about to fall asleep. I would. I would. I'd snore and wake myself up real big or something. Yeah, maybe hairspray. Maybe she does have a hairdo that looks like it would require hairspray. It's the lotion. Thought it was a hard pop. Jessica says she has a Buffalo Bills body lotion t-shirt. That's cool. Kathy says it's fun when the attorneys do crazy things. Says the person who graduated law school but was too chicken to take the bar. What? Why would you do that? Why would you go to school that time and not take the bar? Man. Let's see. That's just driving me crazy. I can't figure out what that thing is. Dry shampoo? She would have dry shampoo on her desk. Duh. What would it be besides? I don't know. End up being a high paid paralegal instead. Okay. Well, good for you. Good for you. That's awesome. I wanted to, man. I wanted to do something so bad. But this is more fun. So, hey, it wasn't all wasted. This is crazy that they're taking this long. Isn't it? Absolutely crazy. So I guess what the judge is researching this objection that he's given for hearsay. And so the judge is trying to make a decision on that. Yeah, Vicky says Katie, probably a lot less stress. Yes. Absolutely, Miss Kathy. Did any of you guys watch that Rittenhouse trial? That boy, let me see what his first name was. He was found not guilty. That was a really good trial. Kyle Rittenhouse. That'd be a really neat one to kind of cover. It's been was it last year, 2023? Or I guess that would be 2 years ago now. Yeah. And his lawyers did a great job. They really did. He had good attorneys. And that prosecutor that in his case was just, he was awful. He was arrogant, and he wasn't young and he wasn't old. He looked like maybe he was in his 40s. Maybe he was my age or a little bit younger than me, maybe, or something. I could be wrong about that, but it's what he looked like to me. So he wasn't just fresh out of law school. I highly doubt. But he acted like, and the judge even called him out on a whole bunch of stuff. The judge was like, you know better. You know you can't do all this stuff. Maybe we'll just watch some of the big points in that trial. But that would be a neat one to look at. Cinema. Yeah, I love to see good attorneys too, and a good defense attorney. Well, both. I like to see a good defense attorney and a prosecutor. I admire them when they do right, and it's not hard. I mean, we like they're supposed to have tough skin. Anybody that goes into an elected office should have a tough skin, I think. Because you go through campaigns, you should be able to debate. You should know the issues. You should know your talking points. You should know what you're trying to be elected for. Gosh, but we just don't. It's not the way that it is. It's not the way it is. Reality sucks sometimes. Yes, Jessica says, I like them attorneys that make people's teeth sweat. I like this guy. I like this detective, the one that's testifying right now. I mean, I don't know him, never seen him before, but I like the way that he comes across. He comes across as a good dude, doesn't he? He comes across as a good detective. What I've heard so far, he does. It's the truth. You can never get a second chance to make a good first impression. This guy's already made a good first impression on me, and I bet he has the jury too. Oh, you didn't see the Rittenhouse trial? Well, I will do that one. So you just hang on, honey. You do it. You come watch it with us. It's very educational too, because the whole case is a Second Amendment case. He had taken one of his pew-pews, a long one that he had, not a hand-held one. It was a long one. And they all went down to like where they were rioting. I forget what state it was in, but they went to where the riots were going on. And it was, I think it was the Black Lives Matter protests and stuff like that. And so a bunch of people ARMED themselves and went down to the riots or wherever the protest was going on. It wasn't really a riot. It was just protesting and stuff, but it was starting to get out of control. And so he went down there and somehow he ended up on a street. It looked like he was by himself, and he was kind of attacked a couple different times. And he ended up pew-pewing like 4 people, but they were all kind of coming at him from a bunch of different directions. Okay, now we're getting, oh no, they're taking her out. Maybe for a break or something. But he ended up, and if they would have found him guilty with the crap that prosecutor was putting on, that would have been one of the biggest injustices, and it probably would have set a big precedent too. So I'm really glad that he got found not guilty. I feel so bad for the people who lost their lives. I know they probably absolutely did not go down there thinking that they were going to, have that interaction. But what do you think? You're taking a risk when you ARMED yourself and you go down looking for trouble. Well, trouble might just find you. And what a lot of people say is they'll defend themselves and they'll use it if they have to. But you got to understand too, more than likely, you're going to be arrested. Even if it is self-defense, more than likely you will be arrested. And then you will have to go to jail and prove until you prove yourself innocent. I mean, we're supposed to be innocent until we prove ourselves, or until we're proven guilty. But the way a lot of us have learned the hard way, I think the system is actually you are guilty, presumed guilty, until you prove your innocence at trial. I mean, I said it last night. I'm guilty of it myself. People get charged with something and you just automatically assume that they're guilty because they're being charged. Because you don't think that the police and prosecutors or whoever would charge an innocent person. But it happens all the time. But so just know that if you have a pew-pew, I went and had my concealed carry. I took my concealed carry class at EKU when I was in school. And that was something that they were very, they stressed it very much in the training and in the class that it's your responsibility, even though everybody has the Second Amendment. You know, we have the right to bear, but it's our responsibility to know the laws associated with carrying. And every state has different laws. Every state has different carry laws. Every state has different self-defense and stand your ground laws. So, you know, if you do carry, you need to really know what the laws are in your state, and what you can and cannot do, and what the consequences are if, God forbid, something was to happen. And then you're looking at attorney's fees, you're looking at fines and costs, restitution, jail time, prison time, felony. I mean, looking at all different kinds of possibilities. Yeah, I think that was her that they took out. Maybe they took her to the bathroom or something. Go ahead and get a bathroom break in while the judge is on this search. I don't even know what he's doing. Tina, I have no filters. Anything can happen. Yeah, I felt the same. Thank God he was found not guilty. Yeah. Prosecutor was meh, but the witnesses were on par. Yeah, I just didn't like that prosecutor at all. Hey, and if you guys have something that you want to send to me, like in the chat, if you've got something that you want me to put up here, put HBIC in the front of the message, just so I know it's for me. If you put HBIC or HC, either one. But Bugman says the one guy he pew-pewed was a convicted R-word. Lois says, I don't feel sorry for him. They were attacking him. Yeah, and, you know, he was on the ground. He was on the ground. Man. And I guarantee you, if you were to talk to him now after that situation, I bet you he feels completely different. Before, he was a young kid. I think he was only like 17 or 18 when he went down there, wasn't it? And it was his friend's pew pew. I don't think he was even old enough to have it. That's why I'm thinking he was 17. I could be wrong about that though. It's been a while. It's been a couple years since that happened, but he was, all gung ho. He heard about them riots, and him and his buddies, there was a whole bunch of people did that. They went and got their pew pews and got all their military gear, hunting gear on, and they ran down to guard the Capitol or the courthouse and stuff like that. Like, they had good intentions, I think. I don't think they were going down there to necessarily hurt anybody. I think they were just nosy. They wanted to be part of it. They wanted to go participate, and made a poor decision to do that, in my opinion. But so they all go down there. And he wanted to be, I think he said he wanted to be in law enforcement or something when he grew up. That's why he was interested in going down there and garden or whatever. But after the trial was over, they asked him about that again, and he said he had completely changed his mind and that he wanted to be a nurse or something like that. So he was going to go to like nursing school or something like that. He had completely changed what he wanted to do. I thought he'd end up going to law school and be a lawyer or something. No, he wanted to go be a nurse or an EMT or something like that. And I think that whole situation just woke him up smacked him in the face real hard. There he was on trial for 4 red rums. There was like 4 people lost their life that night. And it could have very easily went the other way, and he would have spent the rest of his life in prison or possibly even gotten the death penalty. I don't remember if it was even on the table or not. But regardless, 4 dead, yeah, it's going to be, you're not going to get out of prison for 4. So he was very, very, very lucky that the jury came back with the right verdict on that case, in my opinion. What are they waiting on? That's insane, ain't it? Yep, he was 17, they said. Yep. Was it in Minnesota? Yeah, one guy had a skateboard, and they had picked it up like this and was getting ready to hit him in the head with the skateboard. Absolutely. That boy faced threats. Like, he did act in self-defense. I think he did. And there's a video of it. So whenever we do it, we'll play the video. You guys will see it yourself. Those of you that haven't seen it. I think it's pretty self-explanatory. He paid for the pew pew, and the friend was holding custody of it until he was of age. Yeah, the friend actually purchased it because the boy wasn't even old enough to purchase it. So his friend kept it, and then whenever they would go hunting, he would just go with that friend. Kenshaw, Wisconsin. Yeah, it was right on the border. Like, he lived in one state, but they traveled across state lines to go to the protest. someone they knew owned a car lot they went to protect. That's it. That's it. That's it. They were protecting a friend's business, not the courthouse. I didn't know what it was they was going to, but I remember that now. Yep. They were going to protect a friend of a friend's business. Yep. I remember that now. One of the protests, the police were popping the protesters' car tires. They also popped reporters' tires. I didn't know that. An elderly man's business. Yeah. Bugman, they give you a hard time on them caps, don't they? Yeah, there you. Thank you. He said I had the story wrong. I did. Thank you. Kenosha, Wisconsin. Is that the same town that the guy drove his vehicle down through the parade? It was like a Christmas parade. He's a black guy and he killed like, I don't know, 16 people or something like that. It was a whole bunch of people. He ran them over in a parade. Was that in Kenosha? Or am I mistaken that? I might be getting that confused with something else. Those cases were several years ago, or a couple years ago. My memory ain't that good. Everything I have been called for jury duty, I wondered what you do if you have to go potty really bad. Guess you just have to raise your hand. Yep, self-defense. Crystal, see, that case is what got me into these true crime channels. Daryl Brooks, that's who I was thinking of. Thank you, Onyx Angel. Is that the town that he was in? Where was Daryl Brooks? Let me look it up. Daryl Brooks. Waukesha. Waukesha County. What state is Waukesha in? Wisconsin. Waukesha, Wisconsin. It sounded like Kenosha, Waukesha. Lesson: don't skin that smoke wagon if you ain't ready to use it. I'll be your huckleberry. Oh, I love it. I love it. I love it. Don't skin that smoke wagon if you ain't ready to use it. Waukesha, Wisconsin. The sovereign citizen Brooks. Cuckoo, cuckoo, cuckoo. Had that backwards. Yes, Daryl Brooks was pro se for his own defense. Yes, loud. That was both hard to watch and comical. I watched it too. He acted a fool. Yeah, I heard that on Tombstone. I thought that's where that was from. Yeah, that was, what was his name? The actor that, I'll be your Huckleberry. Van or something. Starts with a V. Or it's got a V in it. No shit. Yes, Crystal says, I was so glad that there was videos in the Kyle case. I was too. Imagine if they weren't. Imagine if they didn't have any of the body cameras, if they didn't have any of the videos that they had. That boy would have went to prison forever. Only reason he was found not guilty was because they had that footage. I think, anyway. It's okay, HC. All the towns sound the same in that part of the country. Yes, the Kyle trial was a very, very important case for the Second Amendment. I had to watch it all. It sure was. It's the Second Amendment, Crystal. That's the right to bear arms. Val Kilmer. There you go. That's exactly who I was thinking. I know. Are you kidding? Is the judge looking up these cases in actual law books rather than on LexisNexis? This is insane. Surely to goodness, this ain't. If this is any indication on how this trial is going to go, I think we were wrong. I think it might be longer than 3-4 days or a week. Val Kilmer played Doc Holliday, but Wyatt Earp said that Kurt Russell played him. That was the best movie ever. Yeah. It sure was. Val Kilmer went from a good-looking, great actor with a nice rear to a shell of a man. I think that's what probably happens to a lot of people. Lois says it was a self-defense case, not Second Amendment. I think what they were saying was that case was important for the Second Amendment, because if they had found him, guilty in that, case, that would have set precedent for the rest of the future on how they prosecuted self-defense cases. It's all related. Oh. Val Kilmer was the Iceman in Top Gun. That's right. Now you're telling our age. That was the best movie ever, too. We had some good movies in our day. But the ramifications, if he had lost, would have established precedent. I stopped by the dollar store this morning. Oh. Val Kilmer had cancer. Took a toll on his appearance. I didn't know that. Does on everybody's. Crystal said the attorney on the right looks like my ex-husband. Keeps freaking me out. I can't believe that the judges left everybody hanging like this. But at least they kind of had. I'll tell you something that surprised me so far. I was very surprised that the opening statements were as short as what they were for both sides. Did y'all? Were you surprised with how short the opening statements were? I hope Pink Jacket catches on to the dress code for tomorrow. Cinnamon says it was very much important to our Second Amendment. Exactly. That could have changed everything. It would. Oh, yeah. Oh, yeah. No, I don't think Megan's come back in. There's the judge. My gosh. I love it. I love it. I love it. She looks different than what she did before she got arrested. She looks better, don't she? It's so strange how people can go to jail and that time seems to make them look better. even though jail's rough. It's very rough. But people end up, they just live such horrible lives out here. They don't take care of themselves. They don't, anyway, enough of me talking.
All right, Mr. Scott, you handed me four cases.
4, I think. They're right here. Judge, I handed you the unpublished case of State versus Brewer, and that case contains a pretty good explanation of that it does cite to several published cases. If the version you have of Brewer has a page 12 at the bottom, does it?
Yep.
If you go down to the last paragraph of page 12, it talks about 106 is a rule of timing and admissibility, and talks about whether it's not immediately clear where it would admit the introduction of otherwise admissible hearsay. That paragraph goes on to state, though, however, it has long been the law in the state when a part of a confession or admission is entered into evidence, the defendant is entitled to have the jury consider the entire confession. That cites Curry versus State, 397 Southwest 2nd, 179 at 181. That's Tennessee Supreme Court, 1965. And Samblin v. State, 387 Southwest 2nd, 817 at page 820. And that's, again, Tennessee Supreme Court, 1965. And they go on in this case, they talk about when a confession is admissible, the whole of what the accused said upon the subject at the time of making the confession is admissible and should be taken together. If the prosecution failed to prove the whole statement, the accused is entitled to put into evidence all that was said to him or by him at the time which bears on the subject of controversy, including exculpatory or self-serving declarations connected herewith. It is for the jury to say what weight shall be given to several parts of that statement. For they may well believe the part that which charges the prisoner and reject that which tends to exculpate him. And that's a direct quote from State versus Robinson, 622 Southwest 2nd, 62 at page 71, Tennessee Supreme Court, 1980. And in this case, in Brewer, the Court of Criminal Appeals goes on. This case is kind of almost on all fours the way I see it. The Rule 106 here in Brewer, the state examined on direct examination a witness about a statement. It did not put in a play that did put the physical statement in, nor did the officer read the statement verbatim. But they said the rule of fairness should allow you to place the whole statement in. And I think, Mr. Fraley was asked in this case, he was asked about taking a statement. I think he was asked a couple of times about taking a statement. And he was asked about her admitting that the child was dead. Well, certainly in a missing persons case, when you admit to the police that it's been shown and alleged that you're lying to, and Mr. Fraley, although the court granted an objection, said earlier that she was telling lies. And then when she fesses up and says the baby is dead, certainly the court should take that as a confession. And I think he was asked about the baby being dead, and the response was that the baby was dead, among other things. So that leaves that out there for the jury to be wondering what the other things are. That's my recollection. That's Mr. Horn's notes. Now, that's essentially my argument. I'll rely on the other cases I gave you, but I think that Brewer case gives the best explanation. Although it's an unpublished case, the cases it cites to certainly are published. And if you have any questions, I'll be glad to answer those. If not, I'll yield to Mr. Harper.
Yeah.
Judge, I would agree with Mr. Scott. I think the Brewer case is on point. I would disagree with him as to how he's reading it. However, one, I don't think anything about what I elicited was in any way a confession by Miss Boswell. And two, I would rewind a little bit from where Mr. Scott quoted on page 12 of the opinion, because the danger that we're trying to avoid here is misleading the jury by providing only inculpatory parts or parts that somehow make the defendant put the defendant in a bad light, and not putting forth the parts that are inculpatory or in some way would mislead the jury about the proof. And then the paragraph above where Mr. Scott quoted the rule of completeness that was explained by the Supreme Court, it talks about that the rule must do one of the following, and then it lists four things. One, explain already admitted proof. Two, place admitted proof in context. Three, avoid misleading the trier of fact. Or four, ensure a fair and impartial understanding of the already admitted proof. Well, what he's trying to elicit doesn't do any of that stuff.
See, that's my problem. My problem is I don't know what he's trying to do.
Well,
I have not been told yet.
all right, I guess I'll go ahead. I believe he's trying to elicit that what Miss Boswell told Agent Fraley was that her.
Step out.
And Mr. Suck can correct me if I'm wrong, but I believe what he's trying to elicit is that Miss Boswell told Agent Fraley that Hunter Wood, the defendant's boyfriend, rolled over and killed the child. And that was what she told Agent Fraley at that time. I don't know how that corrects in any way his statement that she admitted the child was dead. I mean, if anything, that's the fact she was there is more inculpatory to elicit that than it is correcting any sort of misleading impression that might be out there as a result of what Agent Fraley's already testified to.
Are you satisfied that that's an accurate summary of what the proof is, or do I need to hear the whole 2 hours? I would, because there's, in this case, I don't recall which one it is, but I read that one of the arguments was that the defendant on possibly the post-conviction case, there was argument that because the judge relied on summary of the proof instead of reviewing the entirety of the proof, that the judge couldn't make that decision.
I think, and Mr. Harper can correct me if I'm wrong, I think I'm generally satisfied with what he's saying, but she explained how the baby died, where the baby, or maybe not where the baby went, but I think that Hunter took it in that statement. Am I right about that? She gives an explanation. And I guess what I'm trying to say right now is it's fundamentally unfair. And I think it does satisfy at least one or two of those things that Mr. Harper's talking about in the paragraph above from Brewer. Explains the already admitted proof and puts it in context. Well, right now you have a case where the jury's heard this TBI agent say, yes, she's lied and she's basically led us on wild goose chases, but she finally admits the baby's dead without putting in the full explanation of what she told them. And I think for the jury to hear that, there's no mention of anyone else in what was put in. She tries to explain to him what happens, and I think it explains it, and it avoids misleading the trier of fact from the standpoint of the jury. You don't know what this proof is. Mr. Harper and me, Mr. Harper, Ms. Maskill, we know it. And I think you said that's where you're struggling. Well, you have,
Well, I mean, obviously it's where I'm struggling,
well,
because the test that the Tennessee Supreme Court is given to the trial judge is that it is an issue of fundamental fairness. It isn't an issue of one snippet of one statement misleads the jury. That's not the test. That's not the question. The question is it fundamentally unfair if I, as a trial, don't allow you to put in the entirety of the statement based on the very narrow, and I understand General Harper was being very careful and cautious in what he was asking. So what I think where we're at is that I'm going to have to, is it transcribed? Is it audio? Is it video?
it's 2 hours.
Well,
I guess we could fast forward to that.
I think I've got a clip of just that portion.
Well, here's the other thing. If you want to give me just a clip, obviously it speeds it up today. But then if the jury ultimately convicts, then on post-conviction or during the appeal, the argument's going to be, oh, well, the judge didn't review the entirety of the statement. And therefore, he couldn't have made an appropriate determination. So here's where we're at. It's my opinion, and believe me, there's nobody in this courtroom who wants to keep this case moving. But it's my opinion that you're going to have to give me the audio, video, whatever it is, and I'm going to have to go back in chambers, and I'm going to have to review it. And then I can come out here and make a decision based on this law. I think that's where we're at. I don't want to send the jury away, but I'm not going to make them sit out here for 2 hours.
I think maybe you're going to have to. I mean, if I'd have known this was going to come up,
I know.
if they'd have known, we'd have brought this up. But I don't
I'm not
think.
mad at anybody.
But I do think the court needs to consider when you do this, is this a confession? Because those state Supreme Court cases that are cited in Brewer go back to 1965, and I don't think.
Well, I'm going to tell you what I'm going to do. And the last case that you gave me gives me this freedom. I'm not going to go back to 1965. I'm going to rely on the rules of evidence as they've been enacted in this state now for some time, and the cases that talk about the rules of evidence. 1965 predates our rules of evidence.
I understand that.
And even our Supreme Court in one of these cases said, look, the defendant in that case made arguments relying on the old cases. The Supreme Court said, look, we're going to look at this under what the rules of evidence say, and that's where that's my story.
I want you to understand my position is this. I think the defendant under due process protections given to her by both the Tennessee Constitution, the federal Constitution, has a right to fundamental fairness. And I think those cases, that's what they're talking about, is fundamental fairness. So
Okay, just sit there.
I'm not sure that there's a difference between if there's the rules of evidence provide for fundamental fairness. I understand what you're saying. Let's make this good. And if I'm wrong, I think we're on the same page at least. Is what needs to be done.
I'll find it. I'll comment about it when we get
Yes, sir.
where we're at right now. Is I'm going to have to bring the jury in. I'm gonna send them, since this is day one and they've not been to the hotel yet, I'm gonna go ahead and just send them to the hotel. So I'm gonna have to listen to or watch.
It's video.
It's big.
And we may have the whole issue about whether I can see and hear what's being said. I've had another case where I had Sullivan County videos that I could not hear.
These are pretty clear, Judge. You should be able, there should be any problems.
So I need to bring the jury in. Well, Lieutenant, so you know, I'm gonna go ahead and send them to the hotel.
Yes, sir.
Let them get settled in. and see what
Yes, sir.
So they're gonna go ahead and
I think
end
you
for the
may
day.
not get in that other case,
I
those
still
statements with the
got it.
Bluetooth.
I still got it.
Did it work that way?
So this jury is sequestered. They said earlier, said this was the first jury that had been sequestered in a long time. I don't remember what it was they said, but it's supposedly the first sequestered jury that's been ordered for a while. So that's interesting. I've not heard of one being sequestered either
Don't stand, please.
in any state, really, in 20 years. Onyx Angel says someone up there said 20 years. Thank you. And I'm pretty sure she's in jail. I don't think she's out on bond, is she? I'm sure that some of you all know that live down there. She looks really good, though. Look at her. I guess she's grew up. Well,
Maybe, thank you.
All right, ladies and gentlemen, I hope you enjoyed lunch first. Second,
thank you, Gentile.
we've got a legal issue that's come up that I have to
Thank you for
do a little bit of
being
research so I can come to the right conclusion. And it's gonna slow us down a little bit. But since this is the first day of sequestration, I'm going to go ahead and have the officers take you to the hotel so you can get settled in. Your luggage should already be there. I think they've already told you all that. Then they'll take you out to dinner tonight to some undisclosed restaurant somewhere in the Tri-Cities. But before you go, I'm required by law to give you certain admonitions. One, you're not to communicate with other jurors or anyone else regarding any subject connected with this trial. You're not to form or express any opinion about the case until it is finally submitted to the jury. You're to report promptly to this court any incident involving an attempt by any person to improperly influence any member of the jury. You're also to report promptly to the court a juror's violation of any of these admonitions. You're not to read, watch, or listen to any news reports concerning this case. You're to decide this case solely on the evidence introduced in this trial. Okay? Now, we'll start back at 9 o'clock in the morning, and I will see you again.
One stand, please.
All right, y'all. Well, we'll see you tomorrow at 9 a.m. We'll do this trial outright. And I'll still have my regular one at 7. We're going to look at that other case that I had ready for last night. So sad. But
You may be seated, thank you.
preventable. It was preventable. Just like this was preventable.
We'll be in recess till 8:30 in the morning. I need y'all to get that statement.
Peace out, Girl Scout. Whoa up now. That's what my mama said. Oh, you're welcome, Miss Kathy. All right. Well, it's over. All right, y'all. I gotta go get my youngins from school. Yes, hashtags. Thank you, Mama Duck. All right, y'all. I'll see you at 7. Y'all enjoy the rest of your day. Peace out, Girl Scout. Bye.